Mr. Brown? Mr. Brown, I show that you're muted and that your camera is off. I can't conduct a hearing if I can't talk to you or see you. And we've called this little party at your request, so I sure hope you will turn on your camera and your microphone. Mr. Brown, it's 11:16. I'm gonna give you about 5 minutes to figure this out. The court has other work, and if you can't figure out the technology, we'll have to reset this again, which I don't want to do. But I show that you're in the Zoom room. I show that you have your camera off and you are muted. So typically you go to the bottom left of your screen, Mr. Brown, and there are two icons, one for a microphone and one for a camera. If you're on an iPhone, I can't really help you with that because I don't know what to tell you to do about that. Ms. Chambers, is Mr. Brown communicating with you via email? I'm trying to help him here, but I don't know what to do if he won't turn on his camera or his microphone.
No, ma'am, I haven't received any more communication from him.
Why don't you send him an email and tell him that we show him in our Zoom room, but we can't conduct a hearing if he won't turn on his camera and unmute himself.
Yes, ma'am.
Thank you.
Judge, he sent me an email saying he's having difficulty with his mic and his camera. I'm going to suggest to him to log out and log back in.
Good idea. All right, everybody else stand by. I'm going to mute myself and make a docket note for my earlier hearing and wait and see what happens. I'm going to turn off my camera as well, Ms. Hutchinson, but we'll wait and see if he can log, Mr. Brown can log out and log back in. So if you
Okay,
just-
Judge.
Thank
Okay.
you. We're ready with our next witness.
Oh, Mark Penley?
Mr. Penley, if you would approach me to be sworn, please, sir.
Yes, sure.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Come right here, the witness stand. Water if you need it. Please speak into the microphone.
All right, thank you, Your Honor. Would you introduce yourself, please?
Yes, Your Honor, my name is Mark Penley.
Your Honor, I'm
Mr.
sorry to interrupt. Could I trouble the court to put the camera back on the witness, please?
I
Thank you.
apologize. I forget sometimes that I'm the director when we have this going, and I forget
Thank you, Judge.
for reminding me. There you go.
I didn't hear that. What just happened?
He asked me to move the camera so that he could see the
Oh,
witness.
Okay,
And I sometimes forget that I've got to run. I've got more jobs when we have a hybrid hearing like this.
understood. All right, thank you. All right, Mark, would you please tell the court about your educational background?
Yes, Your Honor, I went to undergraduate school at the United States Air Force Academy. I graduated in 1976. I then served 5 years on active duty in the Air Force. I resigned my commission as a captain and went to law school at the University of Texas School of Law. And I graduated there in 1984. And I was admitted to practice before the State Bar of Texas and the courts of Texas on November 2nd, 1984.
All right, please tell the court about your professional experience.
Yes. Your Honor, I spent 4 years at Andrews & Kurth in Houston from 84 to 88 practicing commercial litigation. In the fall of 88, I moved back close to home. I went to Dallas to the law firm of Strasburger & Price and was a litigator there until January of 2003. And I left that firm and was with a small firm for a few months until I got a job at the United States Attorney's Office in Dallas. And I was an assistant U.S. attorney in Dallas for 16 years. And I retired from the Department of Justice on September 30th of 2019. And I retired because I've been recruited to join the Office of the Attorney General of Texas by Ken Paxton. I received a phone call from Jeff Mateer that summer of 2019. Jeff Mateer was the first assistant. And he said that Attorney General Paxton had asked him to call me about a vacancy as the Deputy Attorney General for Criminal Justice. So I came down and interviewed and I accepted the position and I began at the OAG on October 8th of 2019.
All right, thank you, Mark. And then later, I do want to, we'll get back to it, but describe to the court what happened after you were terminated. Okay, so we want the court to know that as well. But let me ask you a few things before we go into the details. While you were with the OAG, did you report to the FBI what you believed in good faith to be violations of the law committed by Attorney General Ken Paxton?
Yes, I did on September 30th of 2020.
And as a direct result, were you suspended and later terminated for your reporting violations of the law that you in good faith believed had been committed by Attorney General Paxton?
Yes.
And did you initiate action under the grievance or appeal procedure of the Office of Attorney General related to your adverse personnel action before suing?
Yes, I did that on or about October 12th of 2020.
And so that was within the 90 days after the adverse employment action?
Yes, it was.
All right, thank you.
And if I may add, I received the same response that Mr. Brickman testified to. I was advised by a staff member at the Office of the Attorney General that there was no procedure by which a Deputy Attorney General could file a grievance about their illegal termination.
Now, you've read the petition that's on file in this case?
I have.
And does it accurately state what happened to you and why it happened?
Yes, it does. The paragraphs that specifically deal with me and the activities I was involved in are absolutely correct.
And are you asking this court to adopt the factual assertions made in the petition as being true and correct?
Yes. And if I may add, Your Honor, I believe the rest of the petition is accurate as well, based on what I know from talking to my fellow whistleblowers and the testimony during the impeachment trial and the other sources of public information, including the thousands of documents on file in the Texas Senate. But I want to reaffirm the paragraphs that deal specifically with what happened to me and what I was involved in are 100% accurate.
Now, you stated that the position that you were hired for at the OAG was the Deputy AG for the criminal justice section?
For criminal justice.
You were head of the criminal section?
Yes.
Okay.
Yes.
And what was your salary at that time?
I had the same salary as Mr. Brickman, $205,000 per year.
And when did that come to an end?
I was illegally terminated on November 2nd, 2020 by the new first assistant, Brent Webster, on behalf of the Office of the Attorney General.
All right. And I would like for you to summarize for the court, give an overview, brief summary of what the events were that led to your suspension and then termination.
Yes. Your Honor, I was not directly involved in the things that went on in the other departments. And in fact, part of this that struck me when I later found out the whole picture was the way the Attorney General compartmentalized his activities among the different deputies when he was trying to pressure us to do things to benefit Nate Paul, his campaign donor and friend. I first became involved in this pressure after a staff meeting on June 10th of 2020. The Attorney General attended the meeting that day. He was not always at our weekly staff meetings, but he attended that day and said that he had received a criminal referral from the Travis County District Attorney's Office. And so after the meeting, Mr. Maxwell and I read that referral. It was several printed pages, and it was Mr. Paul complaining about activities of the FBI as well as state law enforcement officers, including agents of the Texas State Securities Board and the Texas Rangers, who had executed search warrants issued by a federal magistrate judge in Austin in August of 2019 for searches of Mr. Paul's residence as well as some business locations that he owned. And the Attorney General wanted us to meet with Mr. Paul and his attorney and investigate those allegations. Following that, the first meeting occurred. Mr. Maxwell met with Mr. Paul and his attorney, and I believe that first meeting was on July 21st of 2020. I did not attend that meeting, but the Attorney General called me to his office to watch a videotape of it.
Okay. Yeah, it was recorded and you reviewed the video of the first interview that Maxwell did, correct?
I did.
Right. And what were your thoughts on that?
Well, my thoughts were that the allegations by Mr. Paul and his attorney made no sense. Having been a federal prosecutor for 16 years, I was involved in helping agents obtain search warrants and have them signed by federal magistrate judges on an almost weekly basis. That's a very routine thing done. And based on what they described in their meeting, I saw nothing wrong. I saw that there was nothing untoward about the issuance of the search warrants. They claimed that they had examined the metadata in the documents and that the metadata, and this was a wild assertion, which I believe is totally untrue. They claimed that the assistant U.S. attorney involved in obtaining the search warrant had changed the documents after the warrants were signed by the federal magistrate judge. which would be an insane thing for any federal prosecutor to do. It would not only end your career and get you fired, it would put you in prison. And there was absolutely no evidence that had been done. So Mr. Maxwell and I scheduled the second meeting with Mr. Paul and his attorney. That occurred on August the 5th at the offices of the Attorney General. Mr. Paul and his attorney came again. They went into further detail about the metadata. I think this is an important point, Your Honor. Mr. Maxwell, a veteran law enforcement agent, told them at both meetings the proper agency for them to make a report to about their claims was the Department of Justice Office of the Inspector General. That's a U.S. government official, because he would have access to sealed documents at the federal courthouse. He would have access to documents the FBI maintained. Mr. Maxwell and I both felt there was no way that we as state law enforcement officials could go to the FBI when they were in the middle of a criminal investigation and demand to see their documents. They were not going to show those to us. That's just not done. State law enforcement has its lane. Federal law enforcement has its lane. And, absent extraordinary circumstances, which were not present with this matter, that was never going to happen. So anyway,
There was a second and a third meeting, right? So summarize those.
yeah, so the second meeting was August the 5th. Then a few days later, the very next day, I want to say this, August the 6th, Mr. Maxwell and I met with with IT experts, forensic experts in the IT department of the law enforcement director's department. These people reported to Mr. Maxwell. We explained to them the metadata theory. We had given them the documents that Mr. Paul's attorney had given us. And they said that their theory did not show that anything wrong had occurred. And in fact, just because metadata shows that a document was modified on a date after it was issued, that can result from several innocent things that I knew had occurred. Another document they had given us was the email string between the AUSA and Mr. Paul's defense attorney. So if you change the document to PDF format, that will change the metadata. If you redact a document, that will also change the metadata. And if you encrypt it, that will change the metadata. The email string showed that all three of those things had occurred, Your Honor. And I had that in the emails that Mr. Paul's attorney gave me. So there was no proof of any crime. And yet several days later, I bumped into the Attorney General in the hallway on the 8th floor of the offices of the Attorney General. I told him that we'd had the second meeting. I saw no evidence of any criminal activity by the federal or state law enforcement officials or the U.S. magistrate judge, and recommended that we close the matter, and there was no basis for a criminal investigation. Attorney General Ken Paxton said to me, fine, all I ask that you do is meet with them again and tell them. And I said, fine. So I called Mr. Paul's attorney. We scheduled a meeting for August the 12th. So that was the third meeting.
All right.
And the next day or two, I saw the Attorney General again, and I said, I just wanted you to know I did schedule that meeting. It's on August the 12th. He said, great, I want to attend. So initially we had scheduled it for the Clements building. I moved it to the Attorney General's conference room for the convenience of Mr. Paxton. So we had that meeting, and I announced to Mr. Paul and his attorney that I was recommending that we close the investigation. And immediately the Attorney General started firing questions at me, taking an adverse position to my recommendation, which totally stunned me. And as the meeting went on, it was very unproductive. The Attorney General was not listening to what I said or to what Mr. Maxwell said. Mr. Maxwell was also present. At some point, the Attorney General said he had to leave, and the meeting broke up. And so that was the third and final meeting that I was involved in with Mr. Paul and his attorney.
Okay, so in short, to summarize what was going on, and tell me if this is incorrect, but you were being asked to use the powers of the Office of the Attorney General to investigate the opposition, those investigating Nate Paul. You were being asked to do that by Ken Paxton. You were pushing back at every turn, and yet he kept on pushing you to do the very thing that you're refusing to do. Is that correct?
That's correct. And the reason I was doing that is there was no basis as a prosecutor for me to proceed with a criminal investigation that the Attorney General wanted me to do.
All right. Now, after these events you just described to the court, were you asked to approve the hiring of an outside counsel for the purpose of doing the very investigation into Nate Paul's adversaries that you were refusing to do?
Yes. After that third meeting, I did have another conversation with the Attorney General, and I told him one of the problems was that Nate Paul and his attorney were not giving me all the documents that I realized they had, and that was a red flag. And so then apparently the Attorney General decided he couldn't get me to do what he wanted me to do, so he went behind my back without telling me and decided to hire an outside counsel, as later events proved. And there was a procedure in the office where if a contract for outside services was going to be approved, it had to go through a number of people in the DocuSign program on the office email. So at some point, I believe around September the 4th, I received an email with a DocuSign, and it was a contract or draft contract for the hiring of outside counsel, specifically Brandon Kamek, a 5-year attorney in Houston who'd never been a prosecutor. And I did not sign it.
You refused to sign it, right?
I did ultimately. It got to my inbox on the 4th. I left that same day on vacation. I came back on the 14th, had a meeting with Jeff Mateer, Mr. Brickman, Mr. Banger, and found out that the Attorney General was pushing forward with plans to hire an outside counsel. I still didn't sign it. And then on September the 24th of 2020, the Attorney General called me personally and said he wanted me to sign that contract.
Where was he at the time where did he indicate that he was at the time that he called you, pushing you to sign that contract?
He said he was at the White House. He had just left a meeting in the Oval Office, and he wanted me to sign the contract. And I told him, respectfully, sir, I cannot and will not sign the contract. And I briefly repeated the reasons I'd given him earlier on many occasions as to why there was no basis for me to do a criminal investigation. And as the senior prosecutor in the OAG, I felt it was totally improper for me to pass the buck to an outside lawyer to do something that I believed was improper. If it was wrong for me, it was wrong for somebody else.
And so you told that to Attorney General Paxton while he's in the White House, that you're not doing it, but he was adamant that he was going to come back in town. He wanted to meet with you personally. And in fact, you did meet with him in McKinney, Texas on just what day or a few days later. Is that right?
Yes, that's correct. So
Briefly summarize what went on in that meeting.
I will. The call on September 24th from the White House was about 5 minutes. The next day, he called me back and said, I want to meet with you tomorrow in McKinney. So the second phone call was on Friday the 25th. And then he asked me to come meet with him in McKinney at 2:00 in the afternoon on Saturday, September 26th. We met at a coffee shop, and he wanted to sit outside, which was fine. It was a warm day. We talked for an hour and 45 minutes. And Your Honor, by this time, I was deeply, deeply troubled by the events. I talked to Mr. Paxton on a number of occasions. I had known him years earlier in the early 90s when we worked at the same law firm in Dallas at Strasburg and Price. I came to work here. I considered him a friend. I wanted to be a loyal subordinate. I wanted to serve him well, but more importantly, I wanted to serve the people of Texas well. And I regarded my role as someone who should give good counsel to my boss about criminal matters. And to my knowledge, Ken Paxton has never been a prosecutor. And I was not trying to boss him around, but I was trying to warn him there are red lines in the law when you're engaged in criminal prosecution. So I woke up early on the morning of Saturday, September 26th, and I wrote an outline of bullet points of important points I wanted to tell the Attorney General. And I didn't want him to think I was taking his deposition or anything at our meeting. So I just tried to memorize that outline, left it in the car. And so as we met for an hour and 45 minutes, I covered all the points with him. And I warned him he was getting in dangerous territory, that he could be accused of bribery, because Mr. Paul was a campaign donor. Mr. Paul was a friend of his. The things he was, and by this time I had learned about some of the events going on in the areas of some of the other deputies. And I was concerned with this overall pattern of the Attorney General pushing people to do things to benefit Mr. Paul that did not benefit the people of Texas. Our job is not to represent an individual. Our job at the OAG was to represent the best interests of the state and uphold the law. So we talked for an hour and 45 minutes. The meeting concluded. He asked me again to sign the contract for Mr. Kamek. I again told him I couldn't. I now told him why. I asked him to meet with me and Mr. Mateer the following week. He wanted me to sign the contract so he could pay Mr. Kamek. And I said, well, I'm not an expert on all the state rules for payment of somebody. You know, perhaps somebody else can figure how to get that done, but I can't sign that contract because it's not right.
Now, Mark, soon thereafter, you learned that, in fact, this outside counsel, Mr. Kamek, had been hired, and in fact, to fast forward, you then learned that he had obtained criminal grand jury subpoenas for information that would look into bank records and personal information related to these people that were investigating Nate Paul. Is that right?
Correct. And I'll add another detail. I had heard that Nate Paul was involved in many civil lawsuits. On Tuesday morning, September the 29th, I was working in the office, and about noon or 1 or 2 o'clock, somewhere after lunch, Lacey Mace, the deputy for administration, came to my office and said Jeff Mateer wanted to meet with all the deputies. She had received a phone call from a bank officer in Round Rock. They had been served with criminal grand jury subpoenas by Mr. Kamek, who was accompanied by Mr. Paul's attorney, the same attorney that Mr. Maxwell and I had met with. That's highly improper, but even more improper when we saw the grand jury subpoena, it was not a subpoena for information pertaining to the issuance of the search warrants that Mr. Paul had complained about. It was seeking information about matters in a civil lawsuit that he was involved in. So whether the bank was a party to that lawsuit, I don't know, but perhaps they had information. But it was highly improper to use criminal process to seek documents related to a civil discovery matter.
Okay, this Nate Paul is the same individual that's recently pled guilty to federal crime. Is that right?
It's been reported in the media that Mr. Paul, who was subsequently indicted on 10 or 12 federal counts, has recently pled guilty to one of those counts and is awaiting sentencing in federal court.
All right. Now, for the sake of time, you heard Mr. Brickman testify that there was a moment when the various division heads had a meeting and everybody began to realize how many things were being done in these various divisions that would be beneficial to Nate Paul, right? And contrary to the interests of the state of Texas. Is that you heard him testify to that?
I did.
And if I was to go through and ask you about all those same incidents, would there be anything in which you would tell the judge that you thought Mr. Brickman was not accurate?
No, I thought Mr. Brickman's testimony was very accurate.
Okay. And so the group got together and ultimately, and you were part of that group with the other division heads, right?
Yes, I was. So if I may, Mr. Tittle, the first meeting that we had as a group was on the afternoon of September 29th, when we learned about the first subpoena being served in Round Rock. The next morning, September 30th, we got another phone call that a bank in Austin had been served also a grand jury subpoena obtained by Mr. Kamek, holding himself out as a special prosecutor or some relationship to the OAG. And I do want to correct one thing. Mr. Paxton told me on Saturday, September 26th, that he had already hired Mr. Kamek. What we didn't know was that Mr. Kamek had gotten grand jury subpoenas issued, even though the normal office approval process hadn't been followed. He'd gone and gotten those grand jury subpoenas on Monday, the 28th. So on the morning of the 30th, we learned about the second bank. We have another meeting and we decide we have to stop this. And the only way to do that is go report to law enforcement, because the Attorney General was not listening to any of us.
And so you and the others that Mr. Brickman identified went and met with the FBI. Is that right?
That's correct.
And that was on September 30th?
Yes.
And at that meeting, what were the violations of law that you in good faith believed, or that you reported to the FBI that you in good faith believed had been committed by Mr. Paxton?
Well, number one, I personally believe that Mr. Paxton was attempting to obstruct a federal investigation. So I believed he was engaged in obstruction of justice. Number two, I believed he was involved in some sort of bribery, because I could not understand how any rational public official would take the actions for one individual that Mr. Paxton was trying to take on behalf of Mr. Paul.
So you explained your belief to the FBI of these violations of law, and then within 48 hours, you were suspended. Is that correct?
Yes, that's correct. And I'll echo Mr. Breckman's testimony that on the morning of the 1st, so we went to the FBI the afternoon of the 30th. We were there for 4 hours. The morning of the 1st, we composed a letter to the HR department at the agency and all signed it and sent that letter. And then Jeff Mateer sent the text to Attorney General Paxton, who was in Austin that day, but did not come to the office, that we wanted to meet with him, and also notified that we'd been to the FBI. And Mr. Paxton acknowledged receipt of that sometime that afternoon.
So you were suspended on, what was the date of the suspension?
On Friday, October the 2nd, I received an email or a phone call. I believe it's a phone call from the head of HR that the Attorney General had directed that I be placed on investigative leave. My email was immediately cut off, my agency email, and I had no communications with the office, and I was instructed not to go on OAG property.
All right. Now, did you initiate the grievance procedure at that time or after you were terminated?
I had initiated the grievance. The best of my recollection was, I said October the 12th, but I think it must have been after that, because I was notified on the 15th or 16th of October that my administrative leave was being extended 2 more weeks. And then the final week of October, I was told to turn in my office laptop and cell phone to the office in Dallas, which I did. And I was told to report to the office on Monday, November 2nd, when I was illegally fired. And then I believe it was after that that I initiated the grievance over my firing.
Prior to your termination, or at least, or on the day of, you were called back down to Austin and you were told to sit in a room and you were interviewed by a member of the OAG. Is that right?
That's correct.
That was Brent Webster.
Yes.
He had now become the first assistant.
Yes, he was the new first assistant. That was the first time I ever met him and the only day I ever saw him.
And did you feel that was a sham, that the result was already determined and that this was just for show?
Yes, absolutely. And I'll add this, on 2 or 3 occasions during the month I was on investigative leave, I'd contacted officials of the agency and asked for reasons why I was being investigated. What was the basis for it? I was never given an answer. And then when I was told to come to the office on Monday, November 2nd, I asked again, what's the subject of the meeting on Monday, November 2nd? And I was just told it was for work purposes.
And prior to your being suspended and then later terminated, had you ever been told by Ken Paxton or anyone else at the OAG that you were not meeting job expectations?
No. In fact, Attorney General Paxton personally told me he was glad I was there.
And as with Mr. Brakeman, he personally recruited you to the job.
Yes.
Okay. Now I want to move to the part of this your testimony where we're going to talk about how this has affected your life. Okay?
Yes.
So after you were terminated, when was the next time that you were able to find employment?
I did not find another job or begin work, I'll say, until March 15th of 2021. So I was unemployed for 4.5 months.
And during the time that you were unemployed, you made numerous attempts to find employment.
I did, probably.
You needed to work to support your family, correct?
Yes. I wanted to keep working, and I probably made 40, 50, 60 phone calls trying to find other opportunities.
Eventually, you went to work for the Dallas County District Attorney's Office. Is that right?
That's right.
Now, you went from, tell the court what position you took with the Dallas County DA's office after all the attempts you'd made to find employment. Where did you finally land?
I took an entry-level position as a misdemeanor prosecutor.
And in Dallas County, there in every misdemeanor court, there's 3 prosecutors assigned, basically a chief, a number 2, and a number 3, right?
Correct.
You went in after all your experience in the DOJ and as a U.S. attorney and being the top guy in the OAG, and you became the number 3 prosecutor doing trespasses and DWIs and things like that, right?
That's true.
All right. And we're going to go over your salary numbers in a little bit, but and then eventually you were promoted by the district attorney to a job in white collar. Is that right?
That's right. After 2 months, they moved me up to a felony position in the white collar section.
How did tell us about how getting fired by OAG affected you emotionally?
Similar to Mr. Brickman, Your Honor, this has been an excruciating 4 years. It's been very, very difficult. And I want to say, as an aside, it's been even harder on my wife. It's one thing for me to go through this myself, but for someone I love dearly to have to watch this and sit there and go through this litigation where we've never had any discovery in 4 years, where we never were able to take any depositions, where we were never able to have accountability for the wrongdoing that occurred and the smears that occurred and the attacks on our integrity. The attacks on my honesty and integrity have continued all the way through the amended answer of the OAG, which I reread this morning.
In what you're saying, in every pleading they have filed, they have managed to smear you and the others and say things that were not true, correct?
Correct.
And so you've had to relive that. And there was as Mr. Brickman said, there's a local, a pretty well-known talk show host that's broadcast the Dallas area that routinely talked about this case and called you rogue, and all of you rogue employees, even personally identified you in one broadcast. Isn't that correct?
Well, I don't remember if he identified me, but I know this. I heard the Attorney General interviewed on a Dallas conservative talk radio station on multiple occasions, and on 2 or 3 of those occasions, I recall him being asked about the whistleblower case and our allegations. And the Attorney General made very false statements, very misleading statements. At one point, he claimed he didn't know us, that we'd all been hired by Jet Mateer. That's totally untrue. Mr. Brickman was personally recruited by Mr. Paxton. He recruited me. I had lunch with the Attorney General and one of his aides in November of 2018 when I was completing a 1-year assignment in Washington, D.C. at the Main Justice Department, working in a classified area. And then 7 months later, I got the call from Jet Mateer saying the Attorney General personally wanted me to come interview for the job. So to know that that's how he had treated me and regarded me when I worked for him, and then when all of us stood up to do the right thing and try to stop his abuse of office, then suddenly we're rogue employees, we're insubordinate, we're making false statements, we're liars over and over and over again. That's very hard to hear, because the position we all took was based on our integrity, that this is the rule of law, this is what the law requires. We cannot go outside the boundaries of the law to benefit one person that the Attorney General wants to use an entire state agency to help.
And this emotional turmoil and pain that you went through, it manifested itself in many sleepless nights. Is that right?
That's absolutely true. And they've continued throughout the 4 years. And basically every time we have an event, every time I read a pleading by the OAG or read a brief by the OAG or go through my records trying to get ready for some step in this litigation process, I have another sleepless night. Every time I think about what has gone on, I'm stunned and I'm shocked that the Attorney General and the people helping him with this have gotten away with it.
And tell me if this is true. You have experienced severe anxiety, severe worry, deep concern about the family finances during the time that you were without employment, and also when you were making far less money. All of those things would be true. Is that right?
Yeah, I wouldn't say severe anxiety, but I would say anxiety, definitely anxiety. And I've asked, I'm a Christian, Your Honor. I believe in Jesus Christ with all my heart. And I have sought counsel with fellow Christians and asked them to pray. And many, many people have been praying for me for these 4 years. And Jesus has helped me through this, and my friends have helped me through this, but I have definitely felt emotional pressure and anxiety, and I wouldn't be human if I hadn't, because to go through this and be attacked repeatedly, and even testifying in the impeachment trial was hard because we were attacked there. We were basically accused during cross-examination of not being truthful. And it's outrageous because we all testified. We all gave statements to the investigators from the House, and we all testified under oath. The Attorney General did not testify, and Mr. Webster did not testify. So we're willing to stand up in public, take the oath, and tell what we saw and what we heard and what we did and why. But the Attorney General has never been willing to do that.
All right, Mr. Penley, I'd like for you to turn in the exhibit book there to Exhibit 13 and go over some of the statements made in Dr. David McPherson's economic loss declaration. All right. By the way, Dr. McPherson is an individual that is a economics professor at Trinity University that we hired to perform an analysis of your wage loss. Is that right? And also the effect on your pension?
Yes,
And that's why he's provided a declaration for this court as agreed by Mr. Elvin, we could use that in lieu of him appearing live, correct?
yes.
All right. Now, I'd like you to look at where it starts in section 8. There's a number of bullet points.
Yes, that's correct.
Now, I'm not going to ask to go through every one of these, but you have read these carefully prior to testifying today, correct?
That's true.
And all of these things that we asked Dr. McPherson to assume regarding your lost wages, all of those are true and correct. Is that right?
Yes,
And it explains the amount of money you were making at OAG, and it explains how your successor received raises. And if you had been there, you assume you would have received the same raises, right?
yes. If I can just explain that last point, Mr. Tittle. So when I looked on the Texas Tribune website, I saw that my replacement as the deputy for criminal justice, according to the Texas Tribune, is earning a salary of $241,000 some odd dollars. And so I was earning $205,000 when I was terminated in November of 2020. So I just divided the difference by 4 and assumed that I would have gotten a $9,190 raise per year to get to the current level of $241,000.
I'm sorry, Judge, I have to object, particularly in light of Mr. Penley's statement that he assumed something, that's speculation.
For purposes
Hold
of
on,
this.
let me hear from your counsel. Yes, sir.
Well, go back to the ground rules that the OAG's waived any objection to evidence related to damages. We've established, I mean, that's the whole point in a case like this where he's waiving everything. We're establishing it in a cursory manner for a prove-up.
Well,
Can I respond, Your Honor?
go ahead. Yes,
I'm not
sir.
waiving everything, Judge. I'm not waiving everything. The Attorney General's office has agreed not to controvert evidence of liability or damages. That's what the Attorney General's agreed to do. It's not a default, and I'm not waiving everything. And there's no basis for this witness to testify that he speculates he would have received a raise while he was not employed. That's all. And the court simply needs to rule on it one way or another, please.
Rephrase the question.
All right, you can rephrase the question, but as asked, that objection is sustained. We didn't waive the rules of evidence, and so go ahead.
Okay. You have learned that the individual that now occupies the same job that you had has received substantial raises, correct?
Yes,
Hearsay.
Again, he has elected not to contest any issue of fact in this case as to the claim or damages. Secondly,
Okay, hold on. Objections overruled.
all right. Now, in the economic report of Dr. McPherson, has he gone through and done an analysis of the difference that in the money that you would have made had you stayed at OAG versus the amount of money that you did make while you were a Dallas County District Attorney?
yes, he did.
All right. And through the date of this trial, is that amount of lost wages $484,324?
Yes, that's what he states.
And is that the amount that you're asking this court to award in compensation for wages lost during the period of termination?
Yes, it is.
All right. Now, you liked your job, right?
I liked my job at the OAG very much.
And if things had continued to go well there, more likely than not, do you believe that you would have stayed in your employment with OAG in that position through the end of Attorney General Paxton's current position that ends December 31st, 2026?
Yes,
And in Dr. McPherson's declaration, has he determined the amount of front pay loss that would constitute, that you would have earned had you stayed in that position from the time of this trial forward?
yes, he's come up with a figure in paragraph 11 of $223,197.
And is that the amount that you're asking this court to award in front pay in lieu of reinstatement from the date of trial through the remainder of Attorney General's current term?
Yes, it is.
And Your Honor, on that issue, we can have more discussion about it later, but the issue of reinstatement, we believe is not feasible clearly, and the statute also clearly provides for that remedy of reinstatement. And there is ample case law that in lieu of that reinstatement, when it's not feasible, the equitable relief that can be awarded by the court is the front pay. And that's the reason that we've calculated that number for the court.
Okay.
Now, Mr. Penley, please look at paragraph 9 or section 9 in Mr. McPherson's report.
Yes.
And there's some bullet points there. Do you agree that each one of those are true and correct?
Yes, I do.
Now, this had a very significant, your termination had a very significant effect on your ability to receive a pension that you would have gotten had you stayed through a certain date at OAG, correct?
Correct.
Now, it's explained here in the affidavit, so you don't need to go in great detail, but you purchased 5 years of state employment service essentially because of your military time, right? You were allowed to do that?
Yes, I served 5 years on active duty in the Air Force, and under the rules of the state retirement system, I was able to purchase service credit for those 5 years. So I made a request for them to calculate the amount I would owe, and then I paid that amount in while I was working at the OAG. That amount of money remains on file with the Employee Retirement Board.
And you would have vested in the state pension plan in October of 2024 had you not been terminated, correct?
That's true.
And we're not talking about speculation here as to whether you would have remained working, right? Because you, in fact, were working in the Dallas County District Attorney's Office in October of 2024, correct?
Yes, my understanding is my vesting date would have been October 8th of 2024, and I was employed at the Dallas DA's office on that date and beyond.
And I'm sorry, I may have misstated something earlier about a number, and I just want to correct it for the record, Your Honor. I don't know which number I used, but when I was talking about the front pay number, that had to be reduced to present value, which is identified in the report from the experts. One of the main reasons we provided the court with an expert report. So the present value of the lost front pay was $223,197, and that's the amount that you're asking the court to award in front pay if the court is inclined, right? And that is the amount that's in our proposed judgment, Your Honor. Okay, so with respect to the present value of the lost pension benefit, Mr. Penley, is the number that Dr. McPherson calculated $374,394?
Yes, it is. That's what he states.
And is that the number that you're asking the court to award in actual damages for the present value of retirement plan benefits lost through the date of trial?
Yes.
Right. And lastly, you were required to retain attorneys to represent you on legal matters related to this, right?
Yes, that's true.
And you retained me
Yes, I
within
did.
a few days of your being suspended, right?
Yes, I did.
In fact, you and I have known each other for 30 years. We knew each other back at Strasburg and Price, right?
That's true.
So you called me soon after the suspension, and and you hired me on a contingent fee contract. Is that right?
That's correct.
And that was 33 1/3 contingent fee of
Yes.
any outcome, and I would advance vast majority of the case expenses, right?
Yes, that's true.
And Your Honor, I'll provide testimony about my attorney's fees a little later in the proceeding, but there were two other attorneys. Mr. Penley, you also had to hire two different attorneys at different times during the course of this related to the facts and circumstances here, right?
Yes, that's correct.
You hired Tanya Lucia, is that right?
Yeah, Tanya Lucio is an Austin employment litigation attorney, and I hired her to help me with the filing of the appeal for the wrongful termination to be sure I complied with state law in those regards. And I believe I paid her $15,000. And
$15,255 exactly, right?
yes,
And that's the amount that's going to be wrapped into the total number of the attorney's fees that you're going to ask the court to award you. Is that right?
yes,
And you also hired Johnny Sutton
yes,
to handle matters related to this, and you paid him $22,225.
that's correct.
Okay. And likewise, you'd like that to be wrapped in to the total attorney's fees, and subject to my testimony on attorney's fees and the court's decision on that, ultimately you're going to ask the court to award $438,980 in total attorney's fees, which includes all of the time for my firm and also Ms. Lucio and Mr. Sutton, correct?
That's correct.
All right. Thank you, Your Honor. I'll pass the witness.
Thank you.
Judge, may I ask the witness a question or two?
You may.
Mr. Penley, what was the amount that you paid Mr. Sutton?
I don't have the number in front of me. I believe it was $22,225. Mr. Tittle's got the number in front of him.
That's
but
correct.
I believe that's right.
It's in the record. I appreciate that. I just didn't hear it. But the other question I had was your payment to Mr. Sutton like Mr. Brickman's for advice and counsel regarding your cooperation with law enforcement authorities after you were separated from the Attorney General's office?
No, I retained Mr. Sutton before I was illegally terminated, and it was for advice on how to make the report to law enforcement and matters related to that. So it was previous to the illegal termination.
Your Honor, I just want to object to that question because it assumed, it misstated Mr. Brickman's testimony. Mr. Brickman did not testify that he hired Johnny Sutton only after he was terminated by the OAG. So I would ask that be clarified for the record.
Well, the record will speak for itself.
Thank you.
The record's clear on what Mr. Brickman testified to, Judge, but Mr. Penley, so did you retain Mr. Sutton then in order to advise you about going to make reports of a violation of law before you were fired from the Attorney General's office? I'm just trying to understand the time frame.
Yes.
Okay. And
I retained Mr. Sutton. I retained Mr. Sutton at the latest on September 30th, 2020. It's possible I retained him the previous day. So it's either the 29th or the 30th of September of 2020.
Okay, so the fees that you paid Mr. Sutton, if I understand correctly, and correct me if I'm wrong, were to advise you while you were an employee of the Office of the Attorney General on how you might go about making complaints of violations of law to an appropriate law enforcement authority?
That was the genesis of the retention.
Very
But
well.
he continued to perform legal services for me after that.
What did Mr. Sutton do after that?
Your Honor, I object to Mr. Helfand's questions. He's elected not to contest any issues of facts related to the damages. He's doing exactly that.
No, Judge, if I may respond, I'm not contesting any issues of damages to the extent that they comport with the statute. But the question of Mr. Sutton's fees obviously goes to whether they are recoverable under the statute.
Your Honor, if I might.
You may.
Under the statute, attorney's fees are recoverable. If Mr. Helfand, if we were claiming that we were entitled to lost profits from a business, that would be outside of the statute. We're asking for attorney's fees under the statute. He can make the objection if we're asking for something that has no bearing on the statute, but he's waived this exact line of question. He may disagree with any number of things that would relate to Mr. Penley's damages, but he's elected not to contest it. So I'd object to any further questions along this area.
May I respond, Judge?
You may.
Thank you. Mr. Tittle's assertion is simply incorrect. The statute defines what attorney's fees are recoverable. Not all attorney's fees, only attorney's fees for the prosecution of this lawsuit are recoverable. And it sounds so far like Mr. Sutton has had no role in anyone's prosecution of this lawsuit. It's not all attorney's fees that somebody incurred.
I may be able to clear it up with another question to the witness.
Well, Judge, I was questioning the witness when Mr. Tittle interrupted. Could I continue?
Well, all right, you'll be able to come back. Go ahead.
Thank you.
Penley.
Hold on, no. Mr. Helfand gets to finish his
Okay.
cross-examination.
Your Honor.
Mr. Penley, what work did Mr. Sutton do, if any, in connection with the prosecution of this lawsuit?
Mr. Sutton provided me with advice and counsel on issues related to this entire matter, to the lawsuit, to the ongoing developments in the lawsuit, a number of issues where I felt like I needed someone of his background and expertise. Mr. Tittle is an excellent attorney. Mr. Sutton has some different background that I chose as the client, that I wanted to have two different attorneys coming from two different angles to give me legal advice to handle a situation that I did not create, that I did not choose, and I chose to hire a second attorney and a third attorney because this was a very difficult, challenging legal issue. I did not want to represent myself. It was my free choice to hire Mr. Sutton. He gave me excellent legal services, as has Mr. Tittle and Ms. Lucio. I paid Ms. Lucio and Mr. Sutton out of my own pocket. And as Mr. Tittle said, I have a contingent fee contract with him. It was my choice to hire 3 attorneys, Your Honor.
My question, sir, though, was, let me phrase it a different way and see if we can get to the answer. Did you hire Mr. Tittle when you decided to file the lawsuit, or did you hire Mr. Tittle after somebody else had done work in preparation for you to file a lawsuit?
Well, the whole thing was leading to a lawsuit, Mr. Helfand. I'm not sure if I understand your question.
Maybe tell me what day you hired Mr. Tittle then.
Sometime in October of 2020 is my best recollection. I don't have any notes in front of me, but that's my best recall at the moment.
Was that before or after you stopped working at the Attorney General's office?
Well, I was illegally fired on November 2nd. I was on investigative leave during the month of October, and I was being paid. So I wasn't working in the month of October, but that was not by my choice.
Okay.
But Mr. Tittle was the attorney who signed the plaintiff's original petition on my behalf, if that answers your question.
Has Mr. Sutton ever appeared as an attorney in this lawsuit on your behalf?
I haven't asked him to.
So the answer to the question, no, he is not. Thank you.
Is not because I've not asked him to, but he has been my attorney and has provided legal services in connection with matters in this case.
Thank you.
And
Mr.
yes.
Bennett, can I ask another question? Has he provided you a written bill for his services?
he has.
And do they detail the work that he's done for you?
Basically, it just refers to conferences.
Okay, but there is something that we could see tangible that would explain what Mr. Sutton has billed you for what you've paid, and the court could analyze whether they're reasonable and necessary in connection with the prosecution of this suit, correct?
I have a bill.
Is that a yes to my question, sir?
Yes, I have a bill.
Thank you. I don't have any other questions, Judge. Thank you.
Mr. Tittle, do you have anything to follow up?
Just the last follow-up. In fact, in one of the reports that was published by OAG that you and Mr. Braitman and others feel was quite slanderous.
Yes.
Wasn't one of the issues that you felt particularly slandered you that the OAG suggested that you had actually committed criminal acts?
Yes, and that goes to part of my emotional language damages. Yes.
And it also those are criminal matters of criminal law that Johnny Sutton, with his background, was uniquely qualified to respond to, correct?
Correct.
All right. Nothing further, Your Honor.
Mr. Helfand?
No, Judge, thank you very much. Appreciate it.
Thank you, sir. You may step down.
Thank you, Your Honor.
Thank you. The plaintiff's next witness.
Judge, may I approach?
You may.
I just had a copy of the relief available under the Whistleblower Act. My client, Mr. Maxwell, is not seeking reimbursement for the fees spent with Mr. Sutton. But I just asked the court to note for the benefit of the other plaintiffs, if there's nothing in that statute that says that the fees have to be incurred in connection with the civil suit or anything else. It just says that a public employee whose employment is suspended or terminated, or who is subjected to an adverse personnel action in violation of the act, is entitled to sue for, among other things, reasonable attorney's fees.
Judge, may I respond to the statement? We'll provide the court with the appropriate authority at the appropriate time, but the suggestion that the attorney's fees can be any attorney's fees not related to the prosecution of this lawsuit, I think any suggestion of that is a little bit silly, but I will provide the court with clear authority on what attorney's fees are recoverable under the statute and what aren't.
All right, let's move on.
Thank you, Judge.
Your Honor, as you recall from our prior hearing, opposing counsel in the court allowed us to present Mr. Maxwell by affidavit testimony today.
Since he had just had surgery.
He just had surgery on Tuesday. He is at home. I'm prepared and happy. I'm a poor substitute for Mr. Maxwell, as most human beings would be. I'm happy to read his affidavit into the record if it pleases the court, or if the court would prefer, since the affidavit has been admitted as plaintiff's 12, to simply review it prior to entering judgment.
It's up to you, however you'd like to proceed.
In that case, it is short. I think I'd like to read it today.
All right.
So before me, the undersigned notary public, On this day appeared David
I'm gonna
Maxwell.
caution you, just if you're gonna read,
Uh-huh.
to not go too fast, because it always happens when people read. They read quicker than they speak. And Miss Primo is a really good court reporter, but you can't keep up with people reading too fast.
I understand.
Thank you.
Please give me the high sign if I'm moving too fast. I'll revert back to my Lubbock roots here. Before me, the undersigned notary public on this day appeared David Maxwell, affiant, who upon first being duly sworn upon his oath deposed and stated, quote, "My name is David Maxwell. I'm over the age of 21 years and am fully competent to make this affidavit. I have personal knowledge of the facts stated in this affidavit, which are true and correct. I began my law enforcement career in November 1972 as a state trooper with the Texas Department of Public Safety. I served as a Texas Ranger from March 1986 until November 1, 2010.
Slow down.
I joined the Office of the Attorney General, OAG, on November 1, 2010 as the Assistant Director of Law Enforcement under then Attorney General Greg Abbott. I retired from that position on August 31, 2024, but returned to work in the same position, 2014. Retired from that position on August 31, 2014, but returned to work in the same position on December 1, 2014, as Attorney General Abbott was transitioning to the governor's office. Attorney General Paxton took office on January of 2015 and promoted me to Director of the Law Enforcement Division, a position I held until Attorney General Paxton and OAG terminated my employment on November 1, 2020. My salary with the OAG at the time I was terminated was $186,000 per year. I was an executive deputy in the Law Enforcement Division and the most senior executive deputy in OAG. Prior to the events giving rise to my termination, First Assistant Jeff Mateer was reviewing a request to raise my salary to $205,000 a year, a request I expected to be granted. Were it not for being terminated, I expected to remain employed at OAG through Attorney General Paxton's current term, ending January 1, 2027. In the spring of 2020, First Assistant Jeff Mateer advised me that General Paxton wanted me to talk to a friend of his about some legal issues he was having, which at this time was not specified. Jeff did not give me the individual's name. A couple of months later, Jeff again asked me if I would talk to this friend and contributor to General Paxton, Nate Paul. I did some research and discovered that Nate Paul, a local real estate mogul, was being investigated by the FBI for financial fraud. The amount of fraud alleged was in the hundreds of millions of dollars. Jeff advised me that Nate Paul had alleged some wrongdoing on the part of the FBI during the execution of search warrants on Paul's residence and business. I advised Jeff that we did not have the statutory authority to investigate the FBI while they are conducting a criminal investigation. The FBI and the United States Attorney General's office are not obligated to submit to any subpoenas issued by a state court referencing a federal criminal investigation. Any complaints referencing the actions of the FBI or the United States Attorney's Office should be referred to the Office of the Inspector General, as those two agencies must, by law, cooperate with any investigation initiated by the Office of the Inspector General. Jeff emphasized to me that General Paxton was insistent that I talk to Nate Paul. I advised Jeff that I would agree to talk to Nate Paul, and if he said anything during the interview that I felt would be useful to the FBI, that I would forward that information to them. On June 10, 2020, I met with Nate Paul and his attorney at the time, Michael Wynn, at the security office of the Clements Building, and the meeting was video recorded. Paul complained about the way search warrants were executed by the FBI. I advised him that none of the complaints made by him rose to the level of a crime, and the FBI's conduct was permitted by law. Paul made the complaint that the FBI did not hand him a copy of the search warrants when they executed them. Paul did admit that the U.S. Attorney's Office sent a copy of the search warrants to his attorneys. Paul then made the claim that the metadata indicated that the search warrant had been altered and claimed that the probable cause and the purpose of the search warrants were altered after they were signed by the U.S. District Judge. I advised Paul that his claims did not make any sense and that altering the search warrants after they were signed by the judge would create a situation where the original search warrant that was signed by the judge would not match the one executed by the FBI. I reported back to Jeff Mateer that after my meeting with Paul, it was clear to me that he was a criminal that was probably facing multiple indictments by a federal grand jury. I advised Mateer that General Paxton should stay away from Paul and stop trying to mitigate Paul's situation. I further advised Mateer that if General Paxton continued to attempt to use the power of his office to interfere with a federal investigation, that he could be charged with interfering with a federal investigation, bribery, and abuse of office. I personally told General Paxton that he needed to stay away from Paul. General Paxton did not heed my advice and continued to fight for Paul. During this time, I learned that General Paxton was uniquely focused on Paul and had ordered other employees of OAG, pardon me, to provide Paul with highly unusual, favorable treatment. At that point, I formed a good faith belief that General Paxton was engaging in criminal conduct and using the office of the Attorney General to commit criminal acts. There were 2 more meetings with Paul, the last of which General Paxton was present. In that meeting, General Paxton got very angry with me and threatened to fire me. My job was to manage the law enforcement division of OAG and give General Paxton good, sound advice where criminal investigations were concerned. My advice was sound, but he refused to take the advice. Paul was subsequently indicted and charged with fraud by a federal grand jury. Paul has since pled guilty to 1 felony count of fraud. I reported the information on General Paxton's criminal conduct to the Texas Department of Public Safety Lieutenant Colonel Randy Prince on September 30, 2020, while I was on vacation. After I returned to Texas, I met with the FBI and reported my experiences with General Paxton and Nate Paul to the FBI. On November 1, 2020, I met with the new First Assistant Attorney General Brent Webster and Aaron Reitz. During that meeting, I was treated disrespectfully and was terminated from employment. I have no doubt whatsoever that General Paxton and OAG terminated my employment in retaliation for the report I made to law enforcement. When a police officer separates from a police agency, the agency must fill out a F5 form describing the circumstances of the separation and send it to the Texas Commission on Law Enforcement. The agency has 3 discharge descriptions on the F5 to select from: honorable, dishonorable, or general. General Paxton gave directions to Brent Webster to characterize my separation from the Office of the Attorney General as a general discharge. That selection, which is lesser than an honorable discharge, indicates there was some negative cause for the separation and could even indicate the separating officer is under investigation. A general discharge is a red flag to other police agencies that might be considering hiring you as a certified police officer. There was no factual basis for the Office of the Attorney General to characterize my separation as general. In the following weeks and months, General Paxton described me and the 7 individuals that he fired for confronting him with his criminal behavior as rogue employees and political operatives that wanted his job. I was 71 years old when I was fired by General Paxton. General Paxton made many disparaging remarks about all of us that stood up to him, and on several occasions made derogatory remarks about me and my performance while serving at OAG. General Paxton ended my 48-year law enforcement career working for the state of Texas. Before working for the OAG, I spent 38 years with the Texas Department of Public Safety. For 25 years, I served the state as a Texas Ranger. The emotional toil, reputational damage, and pain and suffering that my family and I have endured because of the actions of General Paxton and the Office of the Attorney General is hard to talk about. My wife and I have 6 married children, 15 grandchildren, and 3 great-grandchildren. I'm well known by the law enforcement community in the state of Texas, and I take pride in my service. I would not do anything different. I have always stood up for what is right, and if I was faced with this situation again, I would make the same decision. There is no wrong time to do the right thing. I have suffered monetary damages due to General Paxton and OAG's conduct in the following categories and amounts. Back pay from November 2020 to February 2025, $871,249.83. Front pay from February 2025 to January 2027, $392,916.59. Emotional pain and reputational damage, $250,000, which the court will note is the cap in the statute. I've also incurred litigation costs and was required to retain the services of an attorney to enforce my rights under the Texas Whistleblower Act. Further, if I say it. Thank you.
All right, it's 12:15. We'll probably ought to take a lunch break. Yes, sir.
Your Honor, can I recall Mr. Penley, just ask him one question just for the record on the emotional anguish amount that he's asking for the court? I don't think I asked that specific number, and I'd just like it to be in the record.
Okay, we can do that before we go to lunch.
And I'll be brief. Thank you. Would you bring that in?
If you come on back up, you remain under oath, sir.
Thank you, Your Honor. All right, Mr. Penley, you've already described the way that this affected you emotionally and the pain and suffering. And are you asking this court to award $250,000 in the amount, in that amount for the emotional pain, suffering, damage to reputation, and inconvenience that you've suffered?
Yes, and for the mental anguish.
Yeah, thank you.
Yes, the full amount.
Thank you.
Thank you, Your Honor.
All right, with that, as I say, it's 12:15. Let's resume at 1:15, 1:30. Give you how much time? How much more testimony do we think we have? I don't want to run short.
Your Honor, one more plaintiff needs to testify. He'll go probably 40 minutes.
Okay.
And then you'll hear briefly from each of the lawyers. That's probably under an hour total.
Okay.
The lawyers are under an hour, so it's under an hour and 40 minutes total.
All right. Then let's be on break until 1:30, please. Thank you.
Thank you.
Thank you. Are we ready to call our next witness?
Yes, Your Honor. The plaintiff called Ryan Vassar.
Mr. Vassar, if you come up here and let me swear you in, please.
May I trouble the court to point the camera at the witness, Your Honor?
Thank you for reminding me. Sorry about that.
Thank you for your courtesy. Appreciate it.
You ready?
Yes, sir.
The challenge of being the last witness is to still be thorough and complete without being repetitive. All right? That's going to be our goal.
All right.
Introduce yourself to the court, please.
I'm Ryan Vassar.
How old a man are you, Mr. Vassar?
I'm 40 years old.
Are you currently employed?
Yes, sir.
Where do you work?
I'm the general counsel of the Cicero Institute. It's a nonprofit think tank here in Austin.
All right. Give us a brief summary, if you would, of your education and your professional employment history.
I attended Texas Tech University for undergrad, continued to law school at South Texas College of Law in Houston. During law school, I interned for 2 federal judges, one on the district court, one on the Fifth Circuit. After law school, in 2012, I served as a law clerk to Justice Don Willett of the Texas Supreme Court. I was at the court for 3 years and then was recruited to work at the Office of the Attorney General beginning in 2015.
All right. Do you have a family?
I do.
Tell us quickly about your family.
My wife's in the back. We have 5 young kids at home.
God bless her. You said you went to the Office of the Attorney General in 2015.
Yes,
Who was the Attorney General at the time?
Ken Paxton.
Why did you want to go work for Ken Paxton?
Well, probably 2 different reasons. When I started at the court with Judge Willett, I was single and not married. And during my time at the court, my wife and I got married, and we were pregnant with her first. So I knew it was an opportunity to take care of a new household, new family, to kind of move in a different direction in my career. Second reason is I was recruited to work at the agency. It was something that I believed in, just the mission of the agency being a pro-liberty, limited government, sort of freedom-focused mission for the people of the state, something that I believed in and wanted to be a part of.
So based on what you knew of Ken Paxton at the time, did the mission of his office align with your personal beliefs and values?
Yes.
What was the first position you held in the Paxton administration?
I was more or less a line lawyer. I started as an assistant attorney general. The AAG positions are basically ranked. So it starts from AAG 1 all the way up to AAG 7. When I started, I was an AAG 3 as an assistant general counsel in the general counsel division.
And did you stay in that position the 5 years that you were there?
No.
What changed?
I was promoted 3 different times. So starting off as assistant general counsel, I was promoted to deputy general counsel. After that, I was promoted to general counsel. And then after that, I was promoted to deputy attorney general for legal counsel.
How old were you when you assumed the position of deputy attorney general for legal counsel?
Oh, what was that? 2020. So I was 36.
Did each of these promotions come with a pay raise?
Yes.
In the nearly 5 years that you held the positions of line lawyer to deputy general counsel, and eventually deputy AG for legal counsel, was your job performance ever evaluated?
It was.
How often?
It was usually annually. The agency had a standard performance evaluation that would occur on an annual basis.
How'd you do?
It was always outstanding feedback.
Prior to the fall of 2020, was your job performance ever criticized?
No.
Were you ever placed on investigative leave?
No.
Or any other kind of leave?
No.
Were you ever reprimanded?
Nope.
Ever disciplined?
No, sir.
How did you get the position of deputy attorney general for legal counsel?
So it was March of 2020. It was shortly after Governor Abbott first declared the disaster declaration for the COVID-19. We were all working from home. One of those days, I got a phone call asking if I would join a phone call with Attorney General Paxton and First Assistant Jeff Batir at the time. In preparation for that future call, I asked if there was anything I needed to be prepared about, if I could answer a question or if I needed to know something going into it. And the answer was no, just be on the call. So on the call, General Paxton offered me the job for Deputy Attorney General for Legal Counsel, just based on my years of experience at the agency and what he referred to as my outstanding performance in the job.
All right. And so what did that job entail?
The Deputy Attorney General for Legal Counsel oversees all of the legal advice functions of the agency, both internally and externally. My divisions that I supervised included the General Counsel Division, which everybody understands is the in-house lawyer for the agency, the Open Records Division, the Opinion Committee, and the Public Finance Division.
How many lawyers at the Office of Attorney General reported to you at age 36?
I think across all the divisions, there were 60 lawyers, in addition to probably around 30 support staff.
All right. And at that time, approximately how many lawyers in total worked for the Office of the Attorney General?
Statewide, between 700 to 800 lawyers.
And how many of those 700 to 800 lawyers served at the level of Deputy Attorney General?
Roughly 12.
How many Deputy Attorneys General were younger than you?
None that I'm aware of.
How many of them rose from the position of line level lawyer to the deputy level in 5 years or less?
None.
Remember what your salary was at the time?
I believe it was $205,000 per year.
All right. How long did you hold the position of Deputy Attorney General for Legal Counsel?
Between April of 2020 to November of 2020.
And why did you leave that position?
I was fired.
What changed for you in the fall of 2020?
And at the very end of September of 2020, the beginning of October of 2020, I came to the realization that General Paxton was using the office for his own personal benefit and for the benefit of his friend, Nate Paul, in ways that I felt were likely illegal and needed to be reported to law enforcement.
Now, you've been sitting in the courtroom today for this entire proceeding, right?
Yes, sir.
And you've heard the other witnesses testify about a meeting with the FBI on the 30th of September, 2020.
Yes, sir.
You were part of that meeting?
Yes,
Were you part of the group that kind of pieced the pieces of the puzzle together that led to that meeting?
that's right.
Is there anything you've heard in the testimony so far that you would either disagree with or that you remember differently?
No, sir.
We've heard that the realization that your group came to regarding the illegal conduct going on in the office was pieced together from different divisions. Is that kind of a fair summary?
That's right.
Were there any of those pieces of the puzzle that you were personally involved in and had personal knowledge of?
Yes.
Can you give us a quick summary of the first piece of the puzzle that you kind of helped figure out?
There were three. The first was the spring of 2020 open records request involving the Department of Public Safety and the FBI's raid on the Nate Paul business and residence that occurred prior in 2019.
Okay. When the Attorney General's office was handling that open records request, did the Open Records Division report to you?
Yes.
Okay, go on.
What would normally have been just a standard run-of-the-mill active law enforcement investigation determination by the Open Records Division not to release the records, we were required to reach a different result at General Paxton's direction.
And did you know at the time that the beneficiary of that decision was Nate Paul?
I knew that he was the requester of the information, but I had never heard his name before.
Got it. Okay. And so did the Attorney General's office on that open records request reach the same decision that you thought would have been the routine required answer in that circumstance?
No, the standard answer for an open records case involving an active law enforcement investigation is to withhold the records.
All right. And you didn't reach that decision in that instance?
No, that was the recommendation, but we were asked to reach a different result by General Paxton.
What was the second piece of the puzzle that you had personal involvement in and helped figure out?
The end of July 2020, I was involved in an AG opinion involving foreclosure sales and whether they should be allowed to proceed under the current executive order governing public gatherings.
By July of 2020, all of us had dealt with the COVID pandemic for a certain period of time, right?
Right.
Fair to say certain states and certain government officials were sort of more cautious and oriented toward closing things, while others were more open toward what they considered to be personal liberties in public gatherings.
Yes.
On that spectrum, where was the state of Texas, and in particular the Attorney General?
So at the point that we were at, it was our consistent practice to favor being opening for business. I believe Governor Abbott and General Paxton had both come out publicly, make statements that Texas is open for business, we're reopening. So our approach at that point, at the end of July of 2020 and the beginning of August, was we were favoring reopening Texas, reopening gatherings, whatever that meant, just on a day-to-day basis.
So I presume the opinion came out in favor of allowing foreclosures to proceed on the outdoor courthouse steps?
That was my initial interpretation of the question.
Yeah. Is that how the opinion came out?
No.
How'd it come out?
I was asked to find the opposite result, that foreclosure sales should not be allowed to continue.
And you were asked by whom?
General Paxton.
And did the letter issue to the effect that foreclosure sales should not be allowed to continue?
Yes.
What time of day and day of the week did the opinion issue?
I was first called to conduct the analysis Friday, probably 4 or 5 p.m. that afternoon. Myself and Deputy First Assistant Ryan Bangert at the time worked on it all weekend, over Saturday and Sunday. I think the opinion finally was released Sunday in the early hours between 2 and 3 a.m.
Did you later learn who benefited from that 2 days later on the first Tuesday of August?
Yes. There was a report in the media, I think on Wednesday, that revealed that some Nate Paul properties that had been posted for sale in foreclosure the preceding Tuesday had avoided foreclosure sale based on the AG's opinion that we had issued.
All right. And what was the third piece of the puzzle that you personally witnessed?
This was the outside counsel contract involving Brandon Kamek So at General Paxton's direction, I drafted the outside counsel contract, which is just the standard form that the agency and all state agencies use to retain outside counsel. In that form, I sent it to General Paxton, sent it to Brandon Kamick. I drafted the scope of services. In the middle of, towards the end of September of 2020, when it first came to light that Mr. Kamick was, number one, misrepresenting himself to others based on the scope of service that I drafted, and then exceeding the scope of services. That was the point where I realized General Paxton was directing Mr. Kamick directly without going through the normal approval process in the agency.
All right, let's unpack that just real quickly. Is it when an outside counsel contract is going to be entered into by the Attorney General's office, was it typical for you in your role to draft the first draft of that contract?
That's right.
Was there a standard process by which the contract would have to go through multiple levels to be approved?
Yes.
Were the approvals ever obtained for the Kamick contract?
No.
We heard that from Mr. Penley that when Mr. Kamick later in the month obtained criminal grand jury subpoenas, he did so by representing himself to be a special prosecutor of the Office of the Attorney General. Did you hear that?
Yes.
Having personally drafted the scope of work on that contract, what was Brandon Kamick ever deputized to be a special prosecutor of the Office of the Attorney General?
No.
All right. You told us earlier that you were part of the FBI meeting that we've already heard about, right?
That's right.
Were you represented by counsel at the time that you participated in the FBI meeting on September 30th, 2020?
Yes.
Who represented you?
Mr. Johnny Sutton.
Why did you engage Johnny Sutton?
This was a new issue for me. Mr. Sutton's experience precedes him. He was a former U.S. attorney. He's an expert in criminal law, and I felt like I needed legal advice just on navigating the criminal aspects and reporting aspects to the FBI.
Looking back on that meeting now, which is 4.5 years in the past, is it or is it not fair to say that that meeting with the FBI has become a focal point of this civil litigation?
Yes.
And when the civil litigation ensued, then did you continue to consult with Mr. Sutton from time to time on the issues that were ongoing in this civil litigation?
I did.
Did you ask me as your lawyer for the civil litigation to consult with Mr. Sutton from time to time?
Yes.
And did I direct you to consult with Mr. Sutton from time to time on issues that I felt were relevant to this case, but which exceeded my expertise?
You did.
All right. Did Mr. Sutton also help guide you through the impeachment process that was related to this case?
He did.
Did you tell the FBI the specific details that you observed and the specific things that you concluded based on your time at the Attorney General's office?
Yes, sir.
Did you at the time tell the FBI you had a good faith belief that you had witnessed illegal conduct at the Office of the Attorney General?
I did.
And based on the FBI's reaction, did they think you were just barking up the wrong tree or wasting their time?
No.
Fiction, speculation, hearsay.
Did they give you a contrary impression?
Yes, they were very interested and concerned about the reports that we had made.
How long did you meet with the FBI?
I met with them on 3 separate occasions. First, with the rest of the group, which was several hours long. And then I was called back individually for 2 separate meetings, both of which were hours in total.
The second and third meetings, were they at your request or at somebody else's request?
No, those were requests from the FBI.
After the September 30th, 2020 meeting with the FBI, did you let your employer know that you had made a report to law enforcement in good faith that you believed you had reported criminal activity by your employer?
Yes, sir.
And is that an exhibit we've already looked at?
Yes, I believe so.
You got the notebook in front of you. Exhibit 1, is that a report to the HR department at OAG?
Yes.
And you signed it?
Yes, sir.
Exhibit 2 is the text that was personally sent to Mr. Paxton regarding informing him that y'all had gone to the FBI?
Yes, sir.
Were you on that text string?
I was.
How did things work out for you after you reported this activity to your employer?
Not great. As the court's already heard, Mr. Mateer, first assistant, resigned that Friday. The new first assistant, Brent Webster, started the following Monday. None of us knew who he was. My first interaction with him was, seeing him always walk around the office with an armed guard.
Did Mr. Mateer normally walk around the office with an armed guard?
No.
All right, go on.
It became clear to me that people were going around my back and meeting with the chiefs and divisions that I was supervising. Decisions were being made without me, excluding me. My laptop was subject to monitoring. So it was just a difficult and frustrating time.
Do you remember the press release that we looked at earlier? That's Exhibit 5.
Yes, sir.
Remember General Paxton issuing a public press release where he referred to you as a rogue employee?
Yes.
You remember Mr. Paxton's lawyers questioning you about that during the impeachment process?
Yes.
You remember you got a little emotional about being accused of such a thing?
Yes, sir.
After the rise that you had unprecedentedly in the AG's office?
Yes, sir.
Do you remember his lawyer then making fun of you for getting emotional on TV for all of us to see?
I do.
How'd that make you feel?
Well, just since the beginning, it's just been frustrating. As everybody's already testified, it's something that we've had to live with for years now. We've had to explain to our young children. At the time in 2020, my wife and I had four kids at the time.
Well, hang on, I'm going to ask you about that in a minute.
Okay.
All right. I want to ask you about that in a minute. But I want to talk about the press releases just a little bit longer. Remember the press releases that accused you of making a false accusation. How did that charge make you feel?
I was furious.
Did you bring that up to Mr. Webster?
Yes.
What did you ask him to do about it?
I asked him to take it down and correct it.
And did he?
No.
All right. Did you, after enduring the public smears, after requesting a retraction of the false statements about you and getting nowhere, after having to deal with a man through an armed guard, after having been your authority undermined, did you file a formal grievance through the HR department at the Attorney General's office?
Yes, sir.
Take a look at Exhibit 8. Is that your formal complaint?
Yes, sir.
In the paragraphs, it's pretty small writing for my old eyes, but did you set out in some detail what you believe to be retaliatory actions taken against you for reporting the illegal conduct of the office to the FBI?
Yes, sir.
What is the date of this formal complaint?
It is dated October 15th of 2020.
Is everything that you wrote in here under the box describe in detail the action, event, or incident about your complaining true and correct?
Yes, sir.
How long did it take you, OAG, to respond?
I think less than 24 hours.
Take a look at Exhibit 9. They closed that file within the very next day?
Yes, sir. October 16th, 2020.
All right. After you filed this formal complaint on October the 15th, what is the next event you experienced at work?
I was placed on investigative leave.
Who placed you on investigative leave?
Brent Webster.
Do you remember the date your leave started?
I don't recall the exact date.
How long was your investigative leave supposed to last?
Initially, it was supposed to last 2 weeks.
And what were you being investigated for?
Despite my repeated requests for an explanation, I was told that the investigation was open-ended.
An open-ended investigation?
Yes, sir.
All right. You said it was originally supposed to last 2 weeks. Did it get extended?
It did. 2 weeks came and went, and I had to contact the HR division to ask what I needed to do. And the response was that I was being extended for another 2-week period.
Did you get a chance to explain any of this to the 60 lawyers in the division that, I mean, in the office that reported to you or anything of the sort?
No.
During the second 2 weeks of your investigative leave, did you file this lawsuit?
Yes.
What happened after you filed the lawsuit?
The day after the lawsuit was filed, I was summoned to return to the office. Unfortunately, I was out of town that day, so we had to reschedule to the following day. I was summoned to the office and informed that the investigation was nearing its end, and had to answer a couple of questions or respond to a couple of accusations involving the open-ended investigation.
Who did you meet with during that time?
It was Brent Webster and Aaron Reitz was in the room also.
And were you able to go right up to their office like normal?
No.
What happened on your way up to the office?
Well, when I was placed on investigative leave, I had to surrender my laptop. My building access was shut off. So upon arrival, I had to check in with security. I was then escorted upstairs to the 8th floor of the building, which is a second access controlled area. Standing outside those secure doors, there was an armed guard who had asked if I had any recording devices on me, and I said no. He said he had to frisk me before I could go into the meeting.
He actually put his hands on you?
Yes.
All right. Anybody witness this?
They did.
Who?
One of the executive assistants at the time, Grace Moody, was standing in front of me.
Did she act like she was accustomed to seeing you treated this way?
No, she was crying.
Did you have any recording devices on you?
No.
What about your phone?
After being frisked, I was also told that I wouldn't be allowed to take my phone into the meeting and that I had to leave it outside.
All right. And so the investigation was almost done at that time, allegedly?
Allegedly.
Did you ever find out what the investigation was about?
No.
All right. What happened next?
After the meeting with Brent Webster and being told that the investigation was nearing its end, I was summoned back to the office the following day, where I was given the option to be terminated or to resign.
Which option did you choose?
I explained that I had done nothing wrong, didn't understand what this was about, and wasn't going to resign.
Did you get fired on the spot?
Yes.
Was that firing sort of a private affair just between you and Mr. Webster?
No, it was very public.
Take a look at Exhibit 10. I guess you were the last survivor. You see the headline there?
Yes, sir.
Last whistleblower fired from Texas Attorney General Ken Paxton's office days after suing for retaliation. That's something you were able to avoid pretty easily?
No.
All right. Let's talk a little bit about the effect that these events have had on you and your family. You told us that you have 5 kids today. What was the situation in November of 2020 when you were fired?
We had 4 kids. Oldest was 5 years old, and the youngest was born in May of that month, or May of that year. So roughly 5 months.
And were you the only breadwinner for yourself, your wife, and your 4 children of age 5 and below?
Yes, sir.
Did OAG give you a severance package or some other means of helping you make ends meet without a job?
No, sir.
Did you have health insurance after you were fired?
Only electing to pay for the COBRA extension, which I paid out of pocket for.
How much did COBRA cost per month more than you were paying for the employees portion of the coverage you had when you were an employee?
It was about $1,300 extra, or the difference between what I was already paying and what I had to cover for COBRA.
How long were you unemployed?
5 months.
So did you spend $6,500 on COBRA, $6,500 extra dollars to COBRA for health insurance during those 5 months?
Yes, sir.
How did you make ends meet?
Just emergency savings, family support, tightening the budget, watching the expenses.
Were any of your children old enough to realize what was going on?
Our 5th grader was. We had to kind of explain what.
Now wait, she couldn't have been in 5th grade then.
Our 5-year-old, sorry.
Okay.
She was definitely not in 5th grade. Our 5-year-old kind of understood that, things had happened and things had changed. I think partly she wondered why I was hanging around the house more than normal. We had to explain to her what being fired meant. She didn't understand what that was.
But she understood enough to ask.
Yes,
But that was a fun conversation.
it was tough.
The statute that you brought this lawsuit under allows recovery, compensation for emotional pain, suffering, inconvenience, mental anguish, loss of enjoyment of life, and other non-pecuniary losses. Do you feel like you suffered any of those things?
I feel like all of it.
Can you just give us a sentence or two summary of what you went through?
Yeah. It's kind of like I was saying earlier, this is something that we've not been able to turn off for almost, I guess, coming up on 5 years now, 4.5 years right now. It's something that has always been hanging over our head. Just been part of the things that we think about, early on. I think one of the first few nights I texted my wife and I just said, I don't know when I'm going to be home, just while we're kind of working through this at the office. And, so I wasn't there that night to put the kids to bed. As the nights kind of went on, I wasn't really hungry, loss of appetite, wasn't sleeping well. I would get mad at myself because I would wake up after having a dream about the office or Paxton. And I was furious because I couldn't control what I was dreaming. But it was just everything I could think about. And then for the next 5 months of applying for jobs, so it was mentally draining, exhausting, frustrating. Kind of changed our approach to finances and budgets just within that 5-month period of looking for a new job. As a family, we shared a lot of tears and just picked each other up and tried to help each other through it.
Let's talk about those job applications. You said you were unemployed for 5 months. Did you try to get a job?
Yes, sir.
Where did you primarily try to get a job?
Well, in November of 2020, when I was fired, I had 7 years and 10 months of retirement service. So my preference was to get another state job just to finish out the 10-year vesting period.
Okay, I was just going to ask you, what was your target to vest? 10 years?
10 years.
Okay, so you were a little over 2 years shy?
Right.
Okay, go on. So you applied for jobs in the public sector?
That's right.
How did that go?
I didn't get any of them.
Well, you were one of the top 12 lawyers in a 700 lawyer agency at the Attorney General's office. Were there no jobs you were qualified for?
The agencies that I was applying for were the agencies that I was also already advising in my role. So, I had a suspicion, why I wasn't getting those jobs.
Well, did you, how many of those jobs did you apply for?
I'd say probably 6 or so state jobs that I can recall.
That you were qualified for?
Yes.
And why didn't you get those jobs?
I never
Section,
got.
lack of foundation, speculation, and hearsay.
Stay.
Without telling us what it is, do you have a pretty strong suspicion why you didn't get those jobs?
I think I was blackballed.
I said without telling us what it is.
Well, yes.
All right. Did you also apply for private sector jobs?
I did.
And is that how you eventually wound up with Cicero Institute?
That's right.
When you got the job at Cicero Institute in April of 2021, were you earning as much as you earned at the Office of Attorney General?
No, sir.
What was your starting salary at Cicero?
$160,000 per year.
So that's 45,000 or so per year less than you had been earning?
Right.
Since then, have you gotten promotions and raises at Cicero?
Yes.
In the intervening 4.5 years, have you kept up with the salary that is paid to the person who occupies the position at OAG that you used to occupy?
I have.
Is that public record?
Yes.
And have you compared that salary to your salary over time at Cicero?
Yes, sir.
Have you finally surpassed what the guy in that position is earning?
Just recently. Yes, sir.
All right. Did you and I build a demonstrative exhibit to track the difference between the salary you've been earning at Cicero for the last almost 4 years and the salary paid to the person in that position at OAG over time?
Yes.
All right. I wonder if I could hand you this demonstrative.
Sure. Thank you.
And is what this demonstrative show, Mr. Vassar, under the column OAG salary, is that the salary paid to the Deputy Attorney General for Legal Counsel at OAG from the day you were fired through the day of trial?
Yes.
And under the column replacement salary, is that the amount that you earned during those same periods of time
That's right.
as expressed as an annual salary?
Yes.
And then under difference, that's math?
Yes. That's the difference.
And so for the period since you were fired and through today, have you earned $137,173.91 less than you would have earned if you stayed in that position?
That's right.
All right. And I see that from starting the beginning of this year, you're now earning some 15% or so more than that person at the Attorney General's office, right?
Yes.
So are you asking this court for any lost wages into the future?
No.
All right. You mentioned that you were close to vesting in the state retirement plan when you were fired. And just quickly, what would it have meant to you in the future had you vested in that plan?
So upon vesting at the 10-year mark, I would have been able to retire with a permanent annuity, a lifetime annuity under the rule of 80, or when I reached age 65. In addition to having the state pay a subsidy of part of my lifetime health insurance coverage.
All right. And did we hire an economist to calculate the net present value to you today of the lost opportunity to have vested in that plan and enjoyed those benefits in your retirement?
Yes.
And can you take a look at Plaintiff's Exhibit 11?
I do.
And you've read over this and studied it carefully before today, right?
Yes, sir.
All right. And since it's in evidence, I don't think we need to spend the time now to go over this man's qualifications and those sort of things. But I do want to ask you on the facts that you asked him to assume in paragraph 8, are every one of those, is the factual information in every one of those bullets true and correct?
Yes.
All right. And based upon those facts, did this economist calculate that you have lost out in gross on a lifetime annuity that would have paid you $749,270?
That's right.
And a health insurance premium benefit in the amount of $273,076?
Yes, sir.
And as he calculated the present value of those losses at $88,580 and $66,534 respectively?
Yes.
And I think this is obvious, but just in case, we talked about Johnny Sutton. Other than him, have you hired any other lawyers to prosecute this case on your behalf?
Only other you.
Last question or two. After you made your good faith report to the FBI and came back to work and told General Paxton what y'all had done, did you want to keep working at the Office of the Attorney General?
I did.
Explain that to us.
Well, I'd already been at the agency for 5 years. I was a new deputy. I was, 5 months in. So I just felt like I had a lot of runway left, and it was the best job in the world. Just with my experience and the stage I was at life. So I loved it. Still believed in the mission at the time and felt like all the work we were doing was important, not just for our little community in Austin, but for the other 30 million Texans.
If Ken Paxton could have put the Nate Paul obsession behind him and gone on with the mission as you described it, would you still be working at the AG's office today?
I believe so.
That's all the questions I have, Your Honor.
May I ask a few questions, please?
You may.
Thank you. Mr. Vassar, looking at this, this document, Exhibit 11, can you tell the court and me what the, what is the lost, in paragraph 9, the lost opportunity to earn the health insurance premium subsidy? What is that?
I'm looking, I see it, end of paragraph 9.
Yes, sir.
So I believe that under the 10-year vesting period, the state pays 50% of the premium payments for the health insurance coverage. I think what that may mean is that's a loss of the 50% subsidy based on not vesting.
I appreciate that. Do you get healthcare insurance from your current employer?
Yes.
And do they pay
Your Honor.
100% of that?
Your Honor,
Hold on 1 second, I have an objection.
I object to the line of questions. Again, in the live answer, the Attorney General's office has pledged not to contest any issue of fact in this case as to the claim or damages. We are claiming damages in the amount set forth in this affidavit, and these questions are contesting that claim in violation of the answer that's on file and that they used to induce the Supreme Court to cut off our discovery.
May I respond, Your Honor?
You may.
I'm not contesting anything. I'm not going to present any evidence of what Mr. Vassar's damages should be, but the court is tasked with entering a judgment in accordance with the law. And the objection seems to suggest that Mr. Vassar can put on evidence that's false in front of the court in an effort to present a higher damage number. I believe the court should know whether the loss of a health insurance premium subsidy is an actual loss to Mr. Vassar. I'm not going to put on controverting evidence, but the court should enter a judgment in accordance with the law that's guided by actual admissible evidence.
May I respond briefly?
You may respond.
2 points. I would never put on false evidence. And 2, he's saying he's not going to controvert the evidence. That's not what he pledged in his answer. He said he wasn't going to contest it, and that's what he's doing.
Let me just say, as a state employee myself, I'm aware.
I'm having trouble hearing, Your Honor. I'm sorry.
So I'm going to allow the question and I'll weigh it appropriately.
Thank you. Mr. Vassar, did you understand the question? Would you like me to repeat it?
You asked, if I recall, do I have current health insurance? Is that correct?
Yes, or does your employer pay for healthcare insurance for you?
Yes, my employer pays for health insurance for as long as I'm employed, but
Very well.
not as any benefit to retirement.
Okay, so they do currently pay, and do you, like you said, you were going to continue to work for the Attorney General's office. Do you presently intend to continue working for your employer?
Yes.
Very well. The only other thing I wanted to ask you about was Mr. Sutton. Has Mr. Sutton ever entered an appearance in this lawsuit on your behalf?
No, not as an attorney of record.
And Mr. Knight said to prosecute this lawsuit. Has Mr. Sutton done anything to prosecute this lawsuit on your behalf?
I have consulted with him. He's consulted with Mr. Knight.
Okay. Can you think of anything specifically that Mr. Sutton did to prosecute this lawsuit as opposed to, for example, advising you as you testified in the impeachment proceeding?
Maybe you can help me understand what you mean by prosecute.
In furtherance of the resolution of the lawsuit that we're here about, as opposed to other matters like the impeachment trial.
I think to take your definition in furtherance of the resolution of the lawsuit, he's served in a capacity as a criminal expert with myself and Mr. Knight.
Okay, thank you. So he's giving you criminal law advice. Did I say that right, sir?
Legal advice with
I'm sorry.
legal advice,
Go ahead, you go.
Question,
You go.
please.
legal advice with respect to his experience in criminal law.
I appreciate your clarification. The only other thing I'm wondering is, did Mr. Sutton give you a written bill for his services?
Yes.
Okay, I appreciate that. Thank you, Judge. That's all the questions I have. Thank you, sir.
Thank you. Do you have any follow-up, Mr. Knight?
No, Your Honor.
Thank you. Thank you, Mr. Best. I'm going to step down. Plaintiffs have further evidence to present.
I think I'm the next witness.
All right, well, let me swear you in then,
Do you want me to say it? I'm going to testify about his attorney's fees.
if you're comfortable up here, yeah.
Sure. I might need some notes though.
I beg the court's pardon. I can't hear the discussion right now. I'm sorry.
He was asking me where I wanted him to sit to testify, and he's coming up to the witness stand. But before
Who
you
is
sit,
that?
it's Mr. Knight.
Okay, Judge, I'm going to raise an objection as to any attorney's fee testimony. There's been no disclosure of any expert witness on attorney's fees in this case.
Y'all want to respond to that? He can't see you unless you sit down.
Can the witness
All right,
respond?
all right, go ahead,
Or
go ahead.
would you like, you know what we're going to say.
Go ahead. What's your response?
I have many responses, Your Honor. One of which is we didn't even reach the point at which we could disclose it. We never got a docket control order in the case because of the way they handled it. Number two, the way the statute is written, attorney's fees are an element of damages that we're entitled to recover, and they said they weren't going to contest that. And number three, this is gamesmanship.
The objection's overruled. All right, now, Matt, I swear you in. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
My name is Joe Knight. I think we've established that. I represent Ryan Vassar in this case. I am the only lawyer of record in this lawsuit who has appeared on his behalf. Your Honor, I currently practice with three other partners at a firm called Ewell, Brown, Blank, and Knight. I've been there since 2015. I graduated from law school in 1990 at the University of Texas. My first job was as a law clerk to Tom Phillips on the Supreme Court of Texas. Your father was serving at the time. We spent some afternoons talking about college football. We didn't talk about cases very much.
Yeah.
He didn't have too much to do with Phillips's chambers on the issues of the court at the time. After I clerked for a year for Judge Phillips, I joined Baker Botts in 1991. I made partner at Baker Botts in 1998 here in Austin. A few years after that, I became the lawyer who was in charge of the Austin-based litigation practice. And then in 2008, I became the partner who was in charge of the entire Austin office. And I held that position until I left at the end of 2014. My standard rate, hourly rate at Baker Botts when I left at the end of 2014 was $825 an hour. My peers who have stayed at Baker Botts in the litigation department currently charge rates of $1,200 an hour, some of them a little bit more than that. I think if I'd stayed there, that's probably what my standard rate would be, or in the ballpark. I have kept my rates lower than that at the smaller firm, and my current standard rate is $875 an hour. I'm generally not a plaintiff's lawyer. I generally don't represent individuals. I made exceptions to both of those rules when Ryan Vassar called me and explained to me what happened to him and asked if I would represent him. As usual, I have kept my time in this case by the hour, and I've charged for it by the hour. From the beginning of the matter in October of 2020 through the time we thought we had it settled in early February 2023, yes, 23, I had worked 367 hours on this case, and I'm rounding that to the nearest whole hour. And I at a rate of $750 per hour for that little over 2-year period. After the state reneged on the deal that we thought we had made, and they filed a new lawsuit in Burnett County, and I'm censoring myself a little bit on here. Ryan and I so renegotiated our deal, and I've worked for $800 an hour since then, although I have told him I would not send him that bill until we prevailed. So I've kept my time and valued it at $800 an hour since then, and I've worked an additional 312 hours on the case. So I've worked a total of 679 hours at a total charge of $524,350. When I was at Baker Botts, because of the administrative responsibilities that I've mentioned, one of my jobs was I had a role in setting the rates that our lawyers charged. So for many years, I had a pretty good handle on what rates were charged for commercial litigation here in Travis County and throughout Texas. I still have many dear friends there, and I've kept up with that information since I left Baker Botts 10 years ago. I think I have a pretty good handle on the going rates and the rates that are charged for lawyers with my level of gray hair and experience. And in my opinion, the rates I've charged in this case are very reasonable for lawyers of my experience. And I know for a fact that there are lawyers with similar experience who would have charged quite a bit higher hourly rate. I will say that ordinarily in a case that lasts 4 years, I would not have performed all of the tasks on the case myself. I would have assigned some of them to associates who charge at a lower billing rate. This case is different in two respects. One, we never really got to those tasks. We never took a single deposition. We've never had a single document to review. We've never had a single interrogatory to respond to, or any of some of the other types of tasks I would ordinarily have delegated. Second, to the extent we've had to do some briefing and some initial drafting and things of that nature, I feel like the plaintiff's lawyers in the case have collaborated quite a bit. Mr. Turner's firm has excellent young lawyers who were often produced first drafts that I would contribute to later. And so I think that saved Mr. Vassar money and saved me hours of working on the case. What I have done on the 679 hours that I described, I was involved, of course, in the initial intake of the case and fact gathering, the drafting of the petition. Mr. Vassar was one of the two plaintiffs who sought a temporary injunction. So I prepared for and actually started presenting his testimony during the temporary injunction hearing that was interrupted halfway through by one of the Attorney General's 7 appeals in this case. I took a significant role in drafting the appellate briefing, both on the initial plea to the jurisdiction and on the multiple mandamuses that they took afterwards. I argued the case in the Court of Appeals against the Solicitor General on behalf of all of the plaintiffs, but of course I charged Mr. Vassar for that. I had an active role in defeating that temporary injunction that they filed in Burnett County and in the appellate proceedings, the mandamus proceedings since then. Until the Supreme Court ruled for them in the most recent one, their record was 0-12 on those appellate proceedings. So I feel like as a team, we delivered quality representation for our client. In my opinion, the amount of hours I have billed in this case are reasonable. The tasks I performed are appropriate for a lawyer at my level and at my experience. I believe I performed the tasks efficiently. And I believe my hourly rate is the 2 hourly rates I billed for are very reasonable. And therefore, my opinion is that reasonable fees for my work on Ryan Vassar's behalf in this case, since it was filed through today, are $524,350. Briefly, I have reviewed the invoices that Mr. Vassar has received from Johnny Sutton, and I've also interviewed Mr. Sutton about the work that he performed for Mr. Vassar. Of course, I know the court knows Mr. Sutton was a U.S. attorney. I've probably referred a dozen clients to him over the years. If I needed to consult with a lawyer about a criminal matter or criminal investigation, he's the only lawyer I would call. Mr. Sutton worked for Mr. Vassar a little over 22 hours in this case, charged him a total of $11,655 at a rate that astounded me, $525 an hour. In my opinion, a reasonable rate for Mr. Sutton's time is easily double that. I think he gave Mr. Vassar a very generous discount. The work that Mr. Sutton performed that has been, all of it, in my opinion, has been a benefit to Mr. Vassar in this lawsuit. He guided him through the initial meeting with the FBI, which has been a focal point of the litigation. It was a focal point of their attack in their plea to the jurisdiction. And it was because the record of that was so good, it helped us allege the things we needed to allege and swear to them to get past that challenge to the court's jurisdiction. I have advised Mr. Vassar to consult with Mr. Sutton on a handful of issues that have arisen in this case as a result of arguments made by the Attorney General's office that I thought he had better expertise than I did on, and I have consulted with him on many of those issues. So I certainly think a mere 22 hours of his time has benefited Mr. Vassar in this case to a great degree. And in my opinion, as I said, both the hours, the tasks, and especially the rate Mr. Sutton charged are very reasonable. And so it is my opinion that a reasonable attorney's fee for Ryan Vassar to recover, in this case for Mr. Sutton's representation, is the amount charged, $11,655. In the court adding the two together, it's my opinion that a reasonable attorney's fee for Ryan Vassar to recover under the Whistleblower Act in this case is $536,015. That concludes my testimony.
Thank you.
May I ask some questions, Your Honor?
Yes, you may.
Thank you. Mr. Knight, when you say the state reneged on the settlement deal, it would be appropriate to say what you meant by that is when the legislature chose not to fund the settlement that the parties agreed to?
No,
Well, did the Office of the Attorney General complete everything that was necessary to present the settlement agreement to the legislature?
I don't think so.
Wasn't the settlement agreement presented to the legislature?
Oh, it was presented.
Right? Did the legislature choose not to fund it?
Well, the legislature didn't fund it.
And after the last legislative session, the legislature chose not to fund it. Did the Attorney General's office offer to the plaintiffs to stand by the settlement agreement and allow the plaintiffs to present it in the next legislative session?
That wouldn't be standing by the settlement agreement.
My question was, did the Office of the Attorney General offer to allow the plaintiffs to present the same settlement agreement for funding to the next legislative session?
We didn't have a settlement agreement at that point. The question doesn't make any sense.
Well, that's the problem. You're changing my question. Did the Office of the Attorney General offer to allow the plaintiffs to present the same $3.3 million settlement agreement to the next legislative session?
So you've again said that we had a settlement agreement, and I say we didn't.
Okay, but the plaintiffs took the position it was no settlement
What I said
agreement.
the agreement is on that exact point. You pretended that the deal did not have a term that required it to be paid that session, but it did.
Regardless of whether we agree on that, Mr. Knight, you're not answering my question. My question was, did the Attorney General's office offer to allow the plaintiffs to present the same $3.3 million settlement, regardless of whether you think it was still an agreement, to the next legislative session?
I don't even know what that means.
Well, Mr. Knight, didn't the Attorney General's office sue, claiming that the settlement agreement was still in force?
You sure did.
And didn't the plaintiffs take the position it was not?
Let's one at a time. Before he was completing his answer. So
I'm sorry.
And then
Could
you may ask.
Maybe if Mr. Knight could pull the microphone a little closer. I thought he was done. I'm sorry. Mr. Knight, as recently as when we met in front of Judge Mauzy, after the legislative session had ended, didn't the Office of the Attorney General put in the record that it was willing to continue to stand by the settlement agreement and allow the plaintiffs to present it to the next legislative session?
Mr. Helfand, we could probably argue about this for as long as the court has left, patience left today. The Attorney General's office took the position that there was still a settlement agreement in place. We believe that that position was wrong. So did the trial court, so did the Court of Appeals, so did the Supreme Court. There wasn't a settlement once the session adjourned without paying.
I appreciate that. That's your position, and I'm not sure I agree with your legal analysis, but it doesn't matter because that's not the question I'm asking you. Did the Attorney General's office offer to stand by a $3.3 million settlement, whether you think it was the subject of a live agreement or not, so that it could be presented in the next legislative session by the plaintiffs?
I have an objection. Hold on. Yes, sir.
I'd object that this has been asked and answered 3 or 4 times. And also, again, reiterate, this is called contesting damages, which he's
Sustained.
he's not going to do.
I think this is contesting damages, and you were really clear, Mr. Helfand, that you weren't going to do that. So,
And the court's ruling, Mr. Knight, the billing records that you've spoken about, are they reduced to writing?
Of course.
Have they been provided to Mr. Vassar?
To Mr. Vassar, some of them have.
Okay, and Mr. Sutton's billing records that you have, are those written records of Mr. Sutton's work that have been provided to you?
Yes.
Have any of them provided to the Office of the Attorney General?
No, if you had sent us a document request, I'm sure that it would have been responsive.
Check the non-responsives after no. Thank you, Your Honor. I have no other questions.
you may sit down.
Thank you.
Next
I'll-
witness.
Your Honor, I'll testify next, please,
All right.
the court. And is it okay if I refer to some notes?
Yes.
If it helps, Judge, and again, obviously, plaintiffs have to decide. I think the court can, I'll be happy to stipulate that each of these lawyers are experienced lawyers who have litigated over many years, who have graduated law school, are licensed to practice in the state of Texas and so on. But if the court wants to hear all that, obviously that's up to Your Honor.
stipulate to qualifications?
I'll stipulate that they're licensed attorneys who can testify about their own fees.
Are you stipulating to the reasonableness and the necessity of the fees?
I'm not stipulating the reasonableness and necessity of fees, Your Honor, and of course, I maintain my objection to any lawyer testifying to fees who has not been disclosed as an expert witness, but I understand the court's already overruled that. May I have that as a running objection as to all four?
The court has overruled that objection, and it's contrary to everything we discussed at our last hearing. I'll add for the record. Please raise your right hand.
I understand the court's ruling. My question was, Judge, can we have that as a running objection, or do I need to make it as to each one?
Sure, you can have a running objection.
Thank you, Judge.
You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you. Please be seated. You may proceed.
Judge, my name is Tom Nesbitt. I represent James Blake Brickman in this lawsuit. I'm licensed to practice by the Texas Supreme Court in the Western, Northern, and Southern Districts of Texas in the Fifth Circuit. I am currently the managing partner at Nesbitt Legal PLLC. I graduated from UT Law School in 1998. That same year, I joined the Labor and Employment section at Fulbright and Jaworski in their Austin office. I left there in 2007 to found the law firm of DeShazo and Nesbitt with Scott DeShazo. On January 1st of this year, Mr. DeShazo left me for a more handsome law partner, Chip Evans, and I founded Nesbitt Legal PLLC. Over 26 years, I've been practicing labor and employment law, advising and litigating for both employers and employees. All of that time in Austin, I have been board certified in labor and employment law since 2007. My billing rate is $600 an hour. My peers at big firms and even boutique employment firms like mine, their billing rates tend to be higher. While I occasionally take a plaintiff's case, I am most often representing employers and executives and other employees in day-to-day advice matters and litigation matters on an hourly rate. I charge $600 an hour, which I believe is below market rate for someone of my years of experience and qualifications. Although I don't take many plaintiff's cases, I took this case on a contingency fee because I believed in my client. I believe in the case. I believe this case is an important one for the rule of law and the proper functioning of government in our state. I took this case also on a contingency fee basis because I wanted my client to have vigorous, zealous representation without the massive cost that would have come to him if I was billing him by the hour. However, I have kept records of my time that I have spent on this years-long, very complicated litigation. From the beginning of this matter, when I was hired in the first week of October of 2020 through today, I have worked 733.9 hours on this case. Will Palmer, who was an associate of my office until the first of this year, is a 2008, he worked 60.10 hours on this case. Will Palmer is a 2008, first of all, he's an Austin High graduate, loyal forever, and he is a 2008 graduate of Yale University and a 2016 graduate of Columbia Law School. He worked in San Francisco in the litigation section of Pillsbury from 2016 to 2020, at which time he moved to Austin and joined our firm. Will worked with us in commercial litigation and employment matters from April of 2020 until December 31st of 2024 when he left, and he's currently an associate in the litigation section at Dubois, Bryant, and Campbell. Will is highly experienced in litigation and legal research. His work on this case was limited, again, 60.1 hours, was limited to doing legal research of the complicated legal issues that this case confronted us with and assisting in the appellate court briefing. His billing rate, if I didn't say it already, is $400 an hour, which I know to be well below market rate for a lawyer of his education and experience practicing employment and litigation in Austin. Therefore, just in summary of the hours, I have worked 733.9 hours at $600 an hour for a total of $440,345. Will Palmer worked 60.1 hours at $400 an hour for a total of $24,040. I believe the rates that we charge are consistent with and reasonable and even below market rate in Central Texas and Travis County for both of our levels of experience. All of the tasks performed in this case have been tasks appropriately performed by Will or me. I have been the lead lawyer for Blake Brickman in the Whistleblower Act case throughout this case. At times, as you'll learn later, I was joined by TJ Turner in representing Mr. Brickman. When we lost a lawyer for one of the other plaintiffs, TJ went to represent that plaintiff to keep up some of the institutional knowledge and not have to bring in another lawyer. My tasks included many things, including advising Mr. Brickman on how to satisfy the administrative prerequisites to a Whistleblower Act case, drafting the petition, working in conjunction with the other lawyers to coordinate strategy, massive fact investigation in this case that went on throughout the case, because despite the lack of discovery, we were constantly learning new information from a variety of sources, some of which aired on television and some that did not. My work also included, of course, opposing OAG's plea to the jurisdiction in this court and Third Court of Appeals in the Supreme Court, defeating their attempt in Burnett County to get an injunction that would have shut down this lawsuit, assisting my client in understanding what his rights were and conferring with the other lawyers in this case. I also, we were within 48 hours of deposing the Attorney General before that was stayed by the Texas Supreme Court. I spent a massive amount of time preparing for those depositions of Ken Paxton, Brent Webster, Leslie French Henneke, and Michelle Smith. And those depositions, like I said, were stayed at the 11th hour. Will's work was also appropriate to his experience. His time was dedicated only to legal research and briefing. In my opinion, the hours I spent on these tasks have been reasonable. The tasks have been appropriate for me to perform. I have performed them efficiently, and my rates are reasonable. Therefore, in my opinion, reasonable fees for my work on Mr. Brickman's behalf in this case over the last 4.5 years are $440,345, and Will Palmer's 60.1 hours for a total of $24,040. Will's $24,040. I have also reviewed the invoice that Blake Brickman received from Johnny Sutton. I have discussed with Mr. Sutton his representation of Blake Brickman. In fact, I observed and was actively involved throughout in most all, not all, but almost all of Johnny Sutton's representation of Mr. Brickman. I won't repeat the testimony about Johnny Sutton's credentials since it's already in the record, but Mr. Sutton's advice and having him as a resource for me and for Blake in the prosecution of this case was instrumental. I'm not a criminal lawyer. There were concepts that were woven throughout this case, and in particular, the criminal investigation division aspect of this case that I had no prior experience and no knowledge with, and Mr. Sutton was instrumental in helping me and the rest of the litigation team understand some of the things that we did not have exposure to. Mr. Sutton charged Mr. Brickman for 20.75 hours at a rate of $525 an hour. I have the same opinion of the reasonableness, the frankly bargain basement discount that he gave that Mr. Knight testified to. So that would be a total of $10,893.75. And again, the tasks Mr. Sutton performed were appropriate for a lawyer of his expertise to perform, and he formed them efficiently. In my opinion, a reasonable fee for Mr. Sutton's representation of Mr. Brickman in this matter is $10,893.75. He sent Mr. Brickman a bill. Mr. Brickman paid that bill. My firm has also advanced costs of litigation in the amount of $2,420.66. My firm paid the filing fee, paid the service of citation fee, paid the fee for a transcript in Burnett County to get the transcript of the case where OAG tried to get an injunction shutting down this lawsuit. We also served subpoenas on Nate Paul and Ken Paxton. We had a certificate of non-appearance issued for one of the depositions that Ken Paxton did not appear for, claiming that he needed to be individually served for it. And finally, we obtained the transcript of the motion for entry of judgment. That was when OAG was trying to shut our lawsuit down, claiming that I can't remember. I think that was not the their claim that we had a settlement agreement, that was when they did the thing they're doing now and claimed, oh, well, we're not going to contest anything. Those costs total $2,420.66. And I submit to the court that these fees and these costs are reasonable.
Thank you.
Thank you.
May I ask a few questions, Judge?
You may.
Before I do, let me say the Office of the Attorney General, while ordinarily, in my experience, costs are not taxed by the court in the judgment, but rather adjusted after a judgment. The Office of the Attorney General doesn't object to the $2,420.66 in cost if the court finds it appropriate to include those in the judgment. As for Mr. Sutton's work, you mentioned the criminal investigation aspect. Is that the criminal investigation that proceeded after your client had separated his employment from the Attorney General's office?
I'm not sure I understand the question.
Well, maybe you could explain what the criminal investigation aspect Mr. Sutton advised on is.
What I am familiar with, what I was referring to was the criminal investigation that Ken Paxton instructed Brandon Kamick to engage in and hold himself out as a fake special prosecutor. That was essentially 1/4 of the criminal conduct that was at issue and is at issue in this case. I didn't know what a grand jury subpoena rule was. I didn't know how you get grand jury subpoenas issued. So Johnny Sutton was an enormous help to me and to Blake, really me, in understanding what are the facts of this Kamick investigation. I think that's what I was referring to.
I appreciate the explanation. So then that would mean Mr. Sutton was providing you and your client information about the propriety or impropriety of Mr. Kamick's work before your client left the Attorney General's office.
No, not just before. No, I'm not sure if he gave him any information or advice about that in particular before he left the Attorney General's office. What I'm talking about is I'm trying to fact investigate this case and understand what went on. Johnny Sutton was an enormous resource for me in understanding what I was reading, what these documents mean. How does the grand jury process work? That kind of thing.
So by the time you were getting Mr. Sutton's assistance, your client had already made what he considered to be a good faith report of a violation of law.
I think that by the time I got involved, he had already made a good faith report of violation of law. So
Is that then a yes to my question, sir?
I think so, but I don't.
Thank you.
I was 4.5, man.
I'm sorry for interrupting. Is Mr. Sutton's bill reduced to writing?
Yes.
Okay. And are your billing records reduced to writing?
Yes.
And have they been provided to your client?
I don't know.
Okay. Have any of the either Mr. Sutton's records or your billing records been provided to the Attorney General's office?
No, you've never asked me for those records, and I haven't provided them, and you know that.
I just need to put it on the record. Is there some? Does it make you unhappy if I ask the question just to put it on the record? I'm sorry. I don't have any other questions, Judge.
I think he said he's finished. Thank you. Plaintiff's next witness. Mr. Tittle, come on up. Let me swear you in. Everybody gets confused about that.
It's kind of confusing. It's like a maze.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. You may proceed.
Thank you, Your Honor. Again, my name is Don Tittle. I'm a 1989 graduate of UT Law School. Immediately after law school, went to work for a firm called Strasburg and Price, which is where I met Mark Penley. And so it wasn't a tremendous time in my life, but meeting Mark Penley was a great moment, and we've been friends ever since. I've operated the law offices of Don Tittle continuously since 1993. My practice is varied. I do mostly and almost exclusively plaintiff's work. Over the years, I've done some criminal defense, I've done personal injury, but for the last 25 years, I've worked, I devoted most of my time to civil rights litigation on behalf of plaintiffs who bring suit under Section 1983. So that's been a lot of my time. But in addition to that, I have handled at least 5 different whistleblower cases. 3 of those that I can remember, in addition to this one, involved the Whistleblower Act, Texas Whistleblower Act, and I've had at least 2 Sabine pilot claims. I've also had, of those, at least 2 of the state whistleblower cases went to verdict, had significant appeals, and I know 1 went to the Texas Supreme Court. So I do have significant experience in this area, as well as other employment retaliation work that I've done. Let's see, following Mr. Penley's suspension, I believe it was in early October when I got a call from Mr. Penley, and he retained me at that time. I represent Mr. Penley on a contingency fee agreement. The agreement is for 33 1/3 of any recovery, with me advancing the case expenses. I believe that a person with my background, I have 35 years of experience. I know that I regularly I get a congratulations from the state bar that have been practicing 35 years, which is one of those things you get. It's not much of a, it's not a great congratulations, but I have a lot of experience, and I believe that a reasonable fee for someone with my background, having tried these cases before, is $800 an hour. I believe that's consistent with other lawyers with my experience, and I believe it's what's customarily charged in the locale and in the state of Texas. There are lawyers in this case that are every bit or in fact have better skills that I think that may be charging less, but in my opinion, they are undercharging for their services. So I believe all of us in this case could be charging more than we are, but I think $800 an hour would be a fair and reasonable amount. Now, although the factors allowing for a multiplier of the hourly rate due to the risks associated with taking on contingency fee agreement, I think are more than justified in this case. I think we meet every one of them. The uniqueness, the risk involved, the collectability issues that we've known about since the beginning, those all exist. I am not choosing to apply a multiplier, so I'm taking a conservative approach in that regard. I've calculated my hours in a conservative manner, and I've excluded hours that may have been duplicated by another lawyer that has done some work in this case for me. I'll talk about his work shortly. The tasks are the same ones that Mr. Knight, Mr. Nesbitt, I'll just briefly read those in the record. The numerous client meetings and phone calls, strategizing with co-counsel, drafting a review of pleadings and motions, legal research, document review and revising numerous appeals, responses to motions to dismiss. Being in from Dallas, Your Honor, I've made numerous trips to Austin that required substantial travel time. Preparation for the mediation itself, the fight after the mediation, consideration of motions to stay, review and responses to literally thousands of emails, defending the breach of contract claims filed in Burnett County, more travel, all-day preparation for that hearing, the hearing itself, more appeals, and of course, time spent preparing for and including this prove-up/trial. So with all of that said, Your Honor, I would conservatively calculate my time as follows: 275 hours through the mediation, with 180 hours additional since the mediation, for a total of 455 hours at a rate of $800 an hour. That would equal $364,000. I have also had work from a lawyer named Roger Topham, who I've employed, and Mr. Topham has approximately 8 years of experience. He's a licensed attorney in Texas, graduate of University of Texas Law School. He's assisted with the work on this case. I conservatively estimated his hours at 75 hours at a rate of $500, which I think would be a reasonable amount for him. That equals $37,500. To my firm in total, that would be $401,500. Additionally, I know that Mr. Penley retained 2 other lawyers, Tanya Lucio, who was very involved in the administrative appeal drafting to make sure that there was no technical error that was made. And she also had some involvement in drafting of the complaint in this lawsuit. And she charged $15,255 total. Mr. Penley testified about paying that bill. Johnny Sutton billed Mr. Penley, and he has paid $22,225. The work by Mr. Sutton, I would like to comment. In every whistleblower case I've had that I can think of, there is a claim, inevitably, there will be two claims in all cases. One, the employee who previously had received outstanding reviews was in fact a horrible employee. That claim will always be made. And secondly, they themselves will be accused of criminal conduct. It happens without fail. In this case, the same thing has happened. Mr. Sutton was far more knowledgeable of criminal matters than myself, and I thought it was very appropriate for Mr. Penley to seek the advice and counsel of Mr. Sutton. And in fact, those concerns did occur in this case when Mr. Brisboe, and I think even before, or I'm sorry, Mr. Elfin at his firm, but I think even before that, if I recall this correctly, Mr. Penley was being grilled by Brent Webster in the days while he was on suspension, the supposed opportunity for him to come in and discuss things. He was accused in that very first hearing of some type of false criminal conduct. I remember Mr. Penley reporting that to me. So even since the beginning, we've known that this would be a tack that the OAG would likely take. So by my calculations of Mr. Sutton's time, it was the total bill that he charged Mr. Penley was $22,225. I believe he himself had 39.30 hours, and there was a balance of a couple of $1,000s for associates at his firm. I believe all of that is entirely reasonable. And if you look at the grand total of hours spent on this case, that's really a drop in the bucket for the kind of protection that and advice that he offered. In total, Your Honor, Mr. Penley is asking for an award of attorney's fees of $438,980.
Thank you.
Thank you.
May I ask a few questions, Judge?
You may.
Thank you. Mr. Tittle, other than the administrative complaint, what is it that Ms. Lucio did?
I know she was actively involved in the drafting of the whistleblower petition.
Okay. Anything else you can tell the court that Ms. Lucio did that would substantiate $15,000 or more in attorney's fees?
Well, I've already mentioned the work on the grievance that Mr. Penley was required to file. And as you know, the petition was not just a mere 5-page start the ball rolling petition. It was a very lengthy, very detailed document. And she and I worked on that together, and we spent a lot of time on it, and we had a lot of hours spent strategizing with co-counsel.
I'm sorry if I wasn't clear. My question was, other than the petition and the grievance, was there anything else Ms. Lucio did that you can tell the court?
I don't, you'd have to ask Mr. Penley. Those are the things that I know of.
Very well. Is Ms. Lucio's time that substantiates the amount that you've told the court is reasonable? Is that reduced to a written record somewhere?
I'm assuming, but I've never seen it. I know Mr. Penley paid it.
Okay. Do you know if Mr. Penley received those records do you know one way or another?
I'm assuming he received some kind of an invoice since he paid the amount.
Mr. Sutton, I think you said Mr. Sutton was valuable to Mr. Penley because even before he stopped working for the Attorney General's office, he perceived a threat that he was going to be accused of a crime or felt like he had been accused of a crime. Did I get that right?
I believe I'm the one that advised Mr. Penley that was likely headed his direction.
But is that why? But I think you said that's what Mr. Sutton was able to do for Mr. Penley, was to confer with him regarding potential, what you would call false allegations of criminal activity on Mr. Penley's part? Right.
Mr. Helvin, I wasn't privy to anywhere near the majority of the conversations between Mr. Penley and Mr. Sutton. I have spoken to Mr. Sutton on a few occasions myself, and I often heard of, I would hear Mark recount what they had talked about, but that's the extent of it.
What I may have asked this question, I apologize, but whatever Mr. Sutton did, is it reduced to a written record of the time that he spent?
I believe it is,
Okay.
but I never I don't have a copy of it, but I believe it is.
Very well. Your time and that of your associate working on this actual lawsuit is reduced to a written record, right?
If you say reduced to writing, it's there were contemporary, some of the time was kept contemporaneously, some was not kept contemporaneously, but there is certainly writing to evidence the time that I spent. I didn't bill for my time hourly, and I don't normally bill for my time hourly, so it's just not kept always contemporaneously.
Okay, but if the court were analyzing the reasonableness of the charges you made for the work that you did, is there a record that has that information?
Well, there's a record that can be provided to the court, yes.
Okay, and can we agree, you've not provided that to the Attorney General's office, have you?
Again, as Mr. Nesbitt said, I've not provided it, and nor has anyone asked.
Right, but I mean, you could have sent it to me if you chose to. You didn't do that, did you?
Well, I would also add that I think we specifically talked about this last or a few weeks ago in our status conference, and we raised the issue that I said to you I was going to do a couple of things, and I said Mr. Nesbitt asked a general question, and I said more specifically, here's what I intend to do. And I have an economic expert by affidavit, and then also just prove up attorney's fees. So I feel like you knew exactly how we were going to proceed today.
Well, my question isn't what you thought I understood. My question is, you could have sent the document to me and you chose not to, correct?
I don't agree with that.
Very well. I don't have any other questions, Judge. Thank you very much.
Thank you. I step down.
Thank you, Your Honor.
I need to give Ms. Primo a break. We've been going for an hour and a half, so let's take about a 10-minute break, and then we'll come back and complete the evidence. Thank you.
Sorry about that, Judge.
That's all right. All right, who's next? Mr. Turner, come on up to the witness stand. You may proceed.
Good afternoon, Judge. My name is TJ Turner. I represent plaintiff David Maxwell in the case. I previously represented, along with Tom Nesbitt, plaintiff Blake Brickman. I graduated from Baylor Law School in February 2004. I was licensed in May 2004, but began working immediately after graduation. My first job as an attorney was as a briefing attorney with the 11th Court of Appeals. I worked for the Chief Justice, Bud Arnott there. My first job in Austin was as Assistant General Counsel for then Governor Perry. After that, I was an Assistant Attorney General under then Attorney General Greg Abbott. About 14 years ago, I left public service and went into the private sector. I took a job at a 2-lawyer firm here in Austin called Kane and Scarnewis, where I still am. I was the 3rd lawyer. We have about 15 lawyers now. I'm primarily a commercial litigator. I represent plaintiffs and defendants in business disputes of all kinds. I mostly work on cases involving construction, business divorces, fiduciary liability, etc. I also do some employment law, and I do some work for governmental entities. I am a member of the Texas Bar Foundation, and in addition to my day job, I was appointed to 2 consecutive terms as a commissioner at the Texas Real Estate Commission, where I served as a commissioner for about 10 years. I have served as an expert on attorney's fees several times in my career. I'm familiar with the factors that the courts analyze to determine whether attorney's fees are reasonable and necessary. I think everybody in here is familiar with Rormus and Arthur Anderson, so I won't go through those now, but I have analyzed the fees that I and my firm have incurred on this case relevant and relative to those factors. So like I said, I was originally approached by one of the whistleblowers and consulted with one of the whistleblowers who did not elect to join this lawsuit. But I worked with some of the other lawyers that were involved, including Mr. Nesbitt, in the formulation of strategy prior to the lawsuit. And when that particular whistleblower elected not to proceed as a plaintiff in the lawsuit, Mr. Nesbitt and Mr. Brickman asked me if I would remain involved. And they asked me if I would remain involved, I hope in part because of my litigation experience, but also in large part because of my background, having worked at the Attorney General's office, having worked at the Governor's office, having been a commissioner at the Real Estate Commission, and having stayed involved, or at least kept a toe in state government and in and around the Capitol. So I readily accepted. I feel the same way about this lawsuit and our team's work on this lawsuit as the other lawyers that have testified today do. I thought this was a noble calling. I think this is the best use of my time I've made with my law license since I had the privilege of being licensed in 2004. I represented Mr. Brickman with Mr. Nesbitt from around November 2020 until December 2022. At that time, Carlos Soltero, who was Mr. Maxwell's previous attorney, had to withdraw after his firm merged with a larger firm. And Mr. Maxwell asked if I would continue in the case and represent him. So I moved from representing Mr. Brickman to Mr. Maxwell, continued to collaborate with the other plaintiffs' lawyers here. As far as attorney's fees go, I would appreciate if the court would take note that I think that was a remarkably efficient transition. We were a couple of years into the case at that time, and Mr. Maxwell, rather than hiring a lawyer that would have to get completely up to speed on what is a complicated, esoteric lawsuit, instead was able to retain my services, which I think actually probably reduced the amount of attorney's fees that were incurred in this case. Like Mr. Nesbitt and Mr. Tittle, I have this case on a contingent fee. My firm has been retained in exchange for 1/3 of any recovery. My firm has borne all expenses associated with litigation. I was on a contingent fee with Mr. Brickman. I'm on a contingent fee with Mr. Maxwell. However, I have contemporaneously tracked my time in this case down to 6-minute increments, as I do in all my cases. I have calculated the value of that time at $500 an hour. I have associates and paralegals at my firm, as well as at least one partner that has put some time in on this case. Their respective rates range from $300 an hour to $450 an hour for the attorneys, and the paralegal rates range from $125 to $150 an hour. I've practiced law in Austin for 20 years. As I mentioned, I've served as an attorney's fees expert before, both here in Austin and surrounding counties. I'm familiar with the rates that are charged by attorneys of my experience and the attorneys at my firm and their level of experience and their acumen. In my opinion, we are well under market on this case, but I considered whether or not we should increase our rate as I did my lodestar calculation. But we also, as you'll hear in a second, spent the most time on this case. So I left the rate where it was. I think that's fair. I think it's reasonable. Like Mr. Tittle, I did not apply a multiplier, and I'm not here to testify as to the value of a contingent fee in this case. Once again, in an effort to be reasonable as I present our fees to this court. So keeping in mind again that my fees are broken up between two plaintiffs. For Mr. Brickman, my firm had a total of 789.7 hours. 698.1 of those hours were mine. The total cost using the lodestar and using the various rates charged by the attorneys and paralegals at my firm, the total value of the services my firm provided to Mr. Brickman is $374,635. There were 5 lawyers and 1 paralegal that had time in the case for Mr. Brickman. As far as Mr. Maxwell goes, there were 3 lawyers at my firm and 2 paralegals that had time in the case, same rate range. There were 767.1 total hours from the legal professionals at my firm. 648.4 of those hours were my own. So the total value of legal services that were provided in this case to Mr. Maxwell by my law firm was $358,017.50. I have limited, just in temporal scope, fee statements from Mr. Soltero that I have reviewed. Mr. Soltero I believe, has been a member of the bar for at least 30 years. He is a graduate of Yale Law School. He's a very, very well-respected employment attorney here in Austin. he was charging $600 an hour, which again, I think is under market. I'm sure he's more expensive now, but I do have time records from Mr. Saltero from April 2022 through November 2022 that reflect 25 hours of work at $600 an hour, which is $15,000 hour. Excuse me, $15,000 total. So I would submit to the court that the total reasonable and necessary attorney's fees that were expended in this case, the value of those services for Mr. Maxwell are $373,017.50. So I believe that both of these figures are reasonable. I believe the work was certainly necessary. This was an extraordinarily complex and time-sensitive, time-intensive case. It's been going on for 4 years. We've had 3 appeals that went up to the Supreme Court, again, on esoteric legal issues. I know I did legal research where I was getting back to cases well into the 1800s, trying to figure out what to do with some of the Attorney General's more novel legal arguments. We defended a separate lawsuit in Burnett County. We defended several mandamus and emergency motions. The case required expertise across a wide variety of areas. We've heard about the expertise that was necessary in the criminal law context. It also required expertise in employment law, sovereign immunity, the Whistleblower Act, legislative appropriation, state agency functions, separation of powers, etc. I have an awful lot of time in this case, and I realize that. My firm, as Mr. Knight mentioned, was happy to take the laboring oar on a large part of the research and rough drafts on briefs. My personal expertise and background was utilized in analyzing issues unique to litigating against the state of Texas, in attempting to facilitate our failed settlement of the suit, in managing media inquiries and communicating with folks in and around the Capitol, in prosecuting Mr. Maxwell's challenge of his F5 proceeding. If you recall, the Attorney General gave him a general discharge. We challenged that at SOA. Mr. Soltero spent some time on that as well, and we were eventually able to get the Attorney General to agree to change that to an honorary discharge. As far as my time, other than those general descriptions, I did the things lawyers usually do. I spent my time analyzing legal issues, researching, doing document review, drafting pleadings, drafting briefs, preparing for the depositions like Mr. Nesbitt. I spent a large amount of time reviewing everything that was produced by the Attorney General's office in the impeachment proceedings to prepare for the depositions that we never got to take. I think that the amount of fees that I've testified to today is definitely reasonable given the amount in controversy. The judgment we'll submit today is going to be around $6.76 million, I believe. As far as Mr. Maxwell, his damage model is 1.8 million. I think spending $350,000 worth of lawyer time to go get 1.8 is actually pretty efficient. We've also had good results. As Mr. Knight mentioned, the Attorney General's office was 0 for 12 before their last Hail Mary worked. And I've never had a party on the other side quit and just say, we're not even going to contest your lawsuit anymore. I think that speaks to the results here. So it's my conclusion based on the factors that the Supreme Court has articulated in Warmoose and Arthur Anderson, and based on our disciplinary rules, that a reasonable and necessary amount of attorney's fees for my firm's representation of Mr. Brickman in this case is $374,635, and a reasonable and necessary amount for attorney's fees, the value of attorney's fees that have been spent in this case representing Mr. Maxwell by both my firm and Mr. Soltero is $373,017.50. That concludes my testimony on attorney's fees.
May I ask a few questions, sir?
You may.
Thank you. Mr. Turner, I think you said you have contemporaneous billing records for the work that you did for both plaintiffs?
Yes, sir, of course.
Okay. Have you provided those to me?
You've not asked for them, Mr. Helfand.
Have you provided them to me voluntarily?
I don't know why I would do that.
Is that a no, sir, that you have not?
No, Mr. Helfand, and you've not asked for them.
Okay, but you're answering a question I'm not asking you, sir. Did you send me any of your billing records?
I've answered your question, Mr. Helfand.
Is it a yes or no?
I've answered your question, sir. You've
Can I
not
ask
asked.
the court instruct the witness to answer the question I asked?
Just answer his question directly, please.
No, I have not sent you my billing records.
Thank you, Mr. Turner. I appreciate that. Now, did you send me Mr. Sotero's records?
No, sir.
Do you have contemporaneous billing records for Mr. Sotero's work to which you've testified?
To the work for which I've testified, yes, I do.
Okay, so you've actually seen written records of the time Mr. Sotero has spent working on the matter before you took over for him?
From only April 22 to November 22, as I testified previously.
Okay, so but the lawsuit was filed in January of 2020, right? Am I correct about that?
That's correct, yes, sir.
Mr. Sotero at that time served
No,
as
it wasn't. It was November of 2020, Mr. Helfand.
Thank you. Mr. Sotero at that time served as Mr. Maxwell's sole counsel in this case, right?
That's correct.
And I'm sorry, you don't have his records from November 2020 until when?
Until April of 22. I wish I did. I would testify as to those two.
Appreciate it. I wasn't asking you what you wish for. I was just asking you what you have. So do those records exist and you don't have them? They don't exist, or you don't know?
I don't know.
Thank you, sir.
I'm also not asking for an award of those fees today.
I'm sorry, sir?
But I'm also not asking for an award of those fees today. The only fees I've requested are those for the time period for which I have contemporaneous written record of Mr. Soltero's time and billing rate.
Thanks, Mr. Turner. If you could just answer the question I'm asking you, we can get done a lot faster.
How it works, Bill.
Did your client pay Mr. Sutton any money?
Not that I'm aware of, sir.
Okay. Did you consult with Mr. Sutton, or did your client consult with Mr. Sutton as far as you know?
Yes, both.
Okay. That's all I have, Judge. Thank you very much, Mr. Turner. I appreciate it.
Mr. Turner, before you leave this in, I have a question.
Yes, ma'am.
And it really doesn't relate to the questions you've been asked by.
I beg your pardon, Your Honor. I can't hear the court.
I'm sorry, I'll speak into the microphone. It doesn't relate to the questions that you've been asked by opposing counsel, but under the Rohrmoos case, do you think that contemporaneous billing records should be submitted? Do we have any concern of, I think you all have adequately testified as to your qualifications, what went into this case, but I just asked that question as a query.
Thank you, Your Honor. And no, I do not believe it's necessary when you have testimony as to the reasonable amount of time, given all the other factors in consideration, and the reasonable value of that time relative to the practice area, the locale where you are. I do not think it's necessary under Rohrmoos or any other case for attorneys to actually present their billing sheets or their invoices or present that to the court. You certainly may as part of your testimony, but if you do a lodestar calculation like every lawyer has today on the stand and you say, this is how many hours I spent, this is the value of that time, that's still sufficient under Rohrmoos.
Thank you.
Yes, Your Honor. Anything else?
You may sit down.
Thank you.
One more witness.
One more witness? All
Tyler
right.
Talbert.
Mr. Talbot, come on up.
Save the best for last,
I'm
Judge.
trying to remember Mr. Knight's admonition, be brief and be exciting.
In another world I used to live in, we called it BIF, brief, informative, factual, and friendly. But that's...
I'll see if I can get 3 out of the 4.
Please stand and let me
I'm
swear you in. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed.
Good afternoon, Judge. My name is Tyler Talbert, and I am one of the attorneys for the plaintiff, Blake Brickman. Mr. Brickman retained me and my firm in February of 2024, so I'm a relative newcomer to the case. And the reason Mr. Brickman retained me at that time was because we had a pending appeal or mandamus in the Supreme Court of the Texas. I am a board-certified civil appellate attorney. I have handled more than 50 civil appeals as lead appellate counsel, many of those pertaining to employment law issues. I've argued employment law cases in the Supreme Court of Texas, in the Fifth Circuit, and various intermediate courts of appeals. Mr. Brickman agreed to retain my firm and myself on an hourly basis. My hourly rate on this case is $325 an hour, which I would suggest is eminently reasonable by Austin standards and reasonable even by Waco standards. I am familiar with appellate work, civil litigation work in Brazos, McLennan, Travis, Limestone Hill, and surrounding counties, and that's a reasonable work for the work performed and charged here. I graduated law school in 2013 after working for a trial court, a court of appeals, and then the Supreme Court of Texas, and I've been with the same firm now for 12, 13 years. The firm of Skanes, Yelverton, Talbert, where I'm a partner. I routinely present on legal topics. I've given probably 40 to 50 CLEs. I'm a member of the State Bar of Texas Appellate Section, the Texas Supreme Court Historical Society, anything there can do that pertains to appeals or the practice of law, I've tried to do. My work in this case primarily consisted of assisting with that appeal, the last mandamus in the Supreme Court of Texas. The legal work was what you'd anticipate. I did legal research. There was writing, as Mr. Turner and Mr. Knight alluded to. There were novel issues that required looking at both state laws, sometimes some federal precedents, sometimes examining issues that had never been argued before. I've never seen an occasion in which a defendant has moved for entry of judgment against itself. It's simply unprecedented as far as I could tell. That included reviewing the existing briefing, as there were many prior iterations of appeals and pleadings in this case. It included examining the current pleadings. It included drafting, editing, collaborating with co-counsel, working with my clients. All of those were the legal tasks that I performed in furtherance of handling that appeal. The bulk of the work that I performed was both in February and then in June of 2024. The reason simply being that's when both the response briefs to the Supreme Court of Texas were due. And so more than 2/3 of the time I ultimately billed on the case were during that time. I do keep contemporaneous billing records. I've reviewed them in preparation for my testimony here today. Obviously, we make those records at or near the time in which the work was performed. We keep those in the ordinary course of business. The billing records show who performed the work, what the work was, how long they spent, and the reasonable rate. Just to answer your question, Your Honor, you'd asked about billing records. Reviewing Rormus, what the Supreme Court of Texas has told us is that all that's required is legally sufficient evidence, and that can be proved with billing records, or it can be proved as it is here today with testimony. I think the language they used was records may be encouraged, but they're not required, I think is the language. Reviewing my billing records, including time up to today, I've billed 94 hours in the case, or $30,450. I believe, having reviewed the records, the work was reasonable and necessary, and that my rate of $325 an hour was fair and reasonable. As I indicated, the bulk of the work was originally in February of 24, filing an initial response to the petition for writ of mandamus, and then subsequently in June of 2024, filing the response brief on the merits. I'm familiar with the standards of recovery of attorney's fees set forth by the Supreme Court of Texas and Rormus. Fees are recoverable in this case. Mr. Brickman retained our firm and agreed to pay us on an hourly basis. To go ahead and address one of Mr. Helfand's questions, I sent those bills to Mr. Brickman monthly, and he's reviewed each of them. And I would request today that we recover $30,450 for attorney's fees for services my firm performed in furtherance of this case, both of which were reasonable and necessary and fair and reasonable. I hope I was brief, informative, friendly, and I forgot the last one. Factual. I was absolutely factual. I will pass myself.
Do you have any questions for this witness, sir?
Yes, Judge, if I may, thank you. I think, Mr. Talbot, when you say we be awarded, you mean Mr. Brickman be awarded your attorney's fees, right?
That's correct.
Okay. Did you write any of the briefs that were submitted to the either the Court of Appeals or Supreme Court?
I did.
And did you argue any matter before the Supreme Court or the Court of Appeals?
The most recent mandamus was not set for argument, so I didn't argue that.
Okay, thanks. You haven't provided me a copy of your billing records, have you?
OAG has neither requested nor received those records.
I'm sorry, is that a yes or a no to the question? You have not provided them to me, have you?
Before any deposition or discovery, you moved for entry of judgment against OAG, so no.
Okay, we object to non-responsive before no. And so why did Mr. Brickman, have you compared your work for Mr. Brickman to the billing done by Mr. Nesbitt in connection with the matters that you were asked to work on?
We've not compared bills, no.
Okay, so in terms of whether there's a duplication of effort on Mr. Brickman's part, as it relates to those mandamus matters that you worked on, you haven't looked at Mr. Nesbitt's records to see whether there is or isn't. Is that right?
As to the appeal and the mandamus, I was primarily responsible for that work on behalf of Mr. Brickman. So there wouldn't have been duplication of efforts with
Well,
Mr. Nesbitt.
Sorry if my question wasn't clear. My question wasn't what you think happened. My question was, have you looked at Mr. Nesbitt's records to see if he billed for the same or similar things that you billed for in connection with the mandamus?
Yeah, and I had answered that 2 questions ago and said, no, I've not reviewed Mr. Nesbitt's billing records.
Thank you. I have no other questions, Judge.
Thank you, sir. You may step down. Do we have any further evidence? I have a question looking at the proposed judgment. I'm gonna let you all argue. I have on page 3 and footnote 3 for Mr. Brickman, $10,893 from Ashcroft Law Firm.
That's Johnny Sutton.
Oh, yeah, okay.
Sorry.
I thought I was paying attention, but all right, that makes sense. All right. So no further evidence.
That is correct, Your Honor. We've
That's
rested and
right.
closed.
All right. Thank you. All right, Mr. Hilton, I'm not going to ask you if you have any evidence because you've already committed that you don't. So,
No, but I think it's probably appropriate for the record that I tell you that I have no evidence and I rest.
thank you.
I would ask the court if the record is closed.
I'm going to hear brief argument if you feel it's necessary.
Is the evidentiary record closed, Your Honor?
Everyone has rested, so yes.
Thank you, Judge. Appreciate it.
Do y'all want to make any argument?
Your Honor, if you would like us to make an argument, we will. Let me just briefly say that I believe we have presented an overwhelming case of the applicability of the statute, good faith reports to a law enforcement agency, termination that was immediate. Not only was there vast evidence of a retaliatory motive in the firings, but there is also a rebuttable presumption that when someone is fired within 90 days of making a report that it was in violation of the Whistleblower Act. The Office of the Attorney General has not even attempted to rebut that presumption. There is also vast evidence of a direct evidence of a retaliatory motive. Your Honor, our judgment contains an accurate, our proposed judgment contains an accurate summary of the damages. I would also point out, Judge, lest we forget this here at the end of the case, that I believe that the Office of the Attorney, I don't really know if they're trying to backtrack on what they told the court, but I do want to just read once again from paragraphs 11 and 13 of their live answer that the OAG hereby elects not to contest any issue of fact in this case as to the claim or damages. Paragraph 13, they say they elect not to dispute the plaintiff's lawsuit as to any issue. Paragraph 14, they say they have instructed its counsel not to contest this lawsuit. I admit to being puzzled by some of the objections and the this and the that, but Your Honor, this evidence came in uncontested, and it easily establishes the plaintiff's entitlement to the damages. I ask that all of the plaintiffs be awarded the amount in the proposed judgment that is before the court.
Thank you. Yes, sir.
May I ask you?
You may.
That last issue, I want to say 2 things. First, on that last issue, I'm going to ask the court to change 2 numbers in the proposed judgment. I'm going to ask them to change them to smaller numbers. We had calculated Mr. Vassar's lost wages on the understanding that his OAG salary at the time he was fired was $206,000 a year. He testified, however, that it was $205,000 a year. As a result of that, I believe his lost wages are overstated by $1,708.33. I believe the number should be, instead of the 137 number, it should be $135,465.58. If we make that adjustment, the prejudgment interest also has to be adjusted downward by $544. Prejudgment interest number should be $125,565.86. And that's because he testified to that lower number. And then briefly, I don't really need to argue the case anymore, but I did want to address the court's specific question. And 2, I was puzzled by the questions about when the billing records were submitted to the other side. I'd be darned if I was going to do that in these circumstances, or submit it to the court. Head note 48 in the Rormus case, I can never pronounce it correctly.
Thank you. I'm glad to hear I'm not the only one who can't pronounce it correctly.
Starts with this sentence, quote, contemporaneous billing records are not required to prove that the requested fees are reasonable and necessary. The court goes on to explain that they're encouraged, but if you read that part of the opinion, the main reason they're encouraged is because the court expects in most cases the issue not to be contested. And it says producing them to the other side facilitates a basis for agreements on reasonable necessity and facilitates or probably permits cross-examination. Those, I had thought about it, certainly, and as I said before, under these circumstances, I was going to be darned if I was going to let them have discovery when they gave us none. And for the same reason, I didn't think that the purposes that sometimes they're required would be served here. And of course, I didn't want to produce them. I tried to testify in great detail in lieu of producing them to the court, because if I produced them to the court, the other side would obviously contest them as well. So I think under Rormus, we have met our burden of proving that they were reasonable in this case, where they're not going to be contested.
Anybody else on the plaintiff's side?
I got it. Thank you.
Thank you. Mr. Helfman, you have anything you want to tell me?
Judge, each time plaintiff's counsel reads you portions of the answer, they cherry pick those portions that they like, but they ignore the statement that says that the Attorney General makes those stipulations so that the Attorney General will not contest the entry of a judgment in accordance with the statute, which they each time omit. The court is still tasked with a judgment that's in accordance with the statute, because that's the court's obligation related to its subject matter jurisdiction. Or put another way, the court can't enter a judgment that exceeds its subject matter jurisdiction, even if, and the Attorney General's office is not consenting to a judgment that exceeds the court's subject matter jurisdiction. So my questions have been focused on that subject matter jurisdiction. I think counsel's interpretation of Rormus and subsequent cases are incorrect. I believe that the court has to have contemporaneous billing records when they're available, so that the court may determine both the reasonableness and necessity. And here, what you've heard is that many of the amounts of, well, there's two problems with the attorney's fees request. One, counsel have already sponsored during, even before they got up and testified about attorney's fees, that the attorney's fees are not limited to those related to the prosecution of this lawsuit. Mr. Turner made that assertion earlier, I think after Mr. Nesbitt made that suggestion. I may be wrong about which counsel said that. We had that discussion during the testimony of one of the plaintiffs. The record will show that the lawyers who testified as to attorney's fees, one, were not properly disclosed. I know the court overruled that objection. Two, did not testify to reasonableness and necessity. Most of them testified to reasonableness of their fees, but not necessity in the prosecution of this lawsuit. And as to the fees that they sponsored of other lawyers, whether it's Mr. Sotero, whether it's Ms. Lucio, and certainly as to Mr. Sutton, the testimony demonstrates that those attorney's fees are not related to the prosecution of this lawsuit. In some cases, they're related to Mr. Sutton's apparent advice to people about.
Let me ask you, Ms. Lucio, as I understood the testimony, helped with the grievance procedure, which was a necessary prerequisite to this lawsuit, wasn't it?
Sure, Judge, but there's nothing in the record. I'm sorry.
So why wouldn't that be reasonable and necessary? If you had to go through those steps, and Ms. Lucio was employed to go through those steps.
Well, the answer to that question, Judge, is the amount of time spent times a reasonable rate for that would be necessary. But Your Honor doesn't have that evidence. You don't have any evidence. You've got a bill of $15,255, and I feel very comfortable in telling the court that preparing that grievance does not equate to a $15,000 plus bill. So the answer to your question is yes, Judge, but therein lies the problem.
Have you prepared a grievance? Have you participated in preparing a grievance in a state agency? Do you have that experience?
No, Judge, but Your Honor has the form in the record. Okay, Judge, if you're going to, I'm not going to quarrel with you. It's your decision, obviously subject to review. If you're going to find it's reasonable and necessary to charge $15,255 to prepare the grievance, I'll leave that to you. I'm simply arguing that I don't think that it is. And I don't think I have to have done it to tell the court that that's an unreasonable fee. But the more important thing, if we zoom back out, is the plaintiffs have not substantiated their burden to demonstrate reasonable and necessary fees in the prosecution of this lawsuit. And That's all I have, Judge, except that I would ask that as to the court's judgment, I think plaintiff's counsel are asking you to enter a judgment today. I asked repeatedly for a proposed form of the judgment. I got one late last night, and then one filled in with numbers during this proceeding. There are problems with that proposed judgment, and I would ask that the court give me some time to work with plaintiff's counsel, see if we can reach an agreement as to the form. Or if otherwise, I can do what I can to address some of the problems that are in the judgment right now, whichever.
Well, it's a really 5-page document. I had hoped that you would have spent the time over lunch to look at it, since I understand it, the only difference from what you received last night were numbers that were testified to today. But how much time do you need to review the judgment? And you can send the court any concerns you have about it.
Well, what I'd like, Judge, is if I can have tomorrow and Monday to confer with plaintiff's counsel, we may be able to reach an agreement as to my concerns. And by Tuesday, submit either an agreed judgment in form to the court, or at least submit my objections.
We're not, there's not going to be, I just feel confident in saying, an agreed judgment. We didn't come here seeking a settlement agreement with the OAG. We came here to have a trial because the OAG said it would not contest any issue of damages or liability. And now Mr. Helfand is heard to say that he has problems with the evidence and the reasonableness of it, of things that he never asked us for, and it is beyond the pale, quite frankly. So, Judge, I would prefer, my request of you is let Mr. Helfand, if the OAG is gonna go back on its word and it is going to object to issues of liability or damages, let him do so on this record right here, so we can allow other courts to see what he has done on behalf of OAG. That is my plea to the court.
May I respond, Judge?
Briefly.
The problem with Mr. Nesbitt's statement is he's misunderstanding my comment. The OAG is not going back on what it agreed to do. Again, the point that the plaintiffs keep missing is the OAG agreed to the entry of a judgment in accordance with the law. And there are problems with the proposed judgment that do not accord with the law. If the court doesn't want me to confer with plaintiff's counsel, or if Mr. Nesbitt is to be heard that the plaintiffs refuse to confer with me about trying to reform those things so as to get to a form of a judgment that may be subject of more agreement or complete agreement, then obviously I would just ask that the court order it. But if the court's not going to, then I don't know what else I can do, Judge. I'm offering to work with any plaintiff's attorney who's willing to look at the concerns I have about the form of the judgment as it accords with the law. They can reject it, but to say right now that they don't want to do it doesn't seem to be helpful to the court.
Just to clarify, Judge, we want to do it right now. Yes, we want, go ahead.
But that's what we're here. We're not looking for a document that's entitled agreed judgment. But if he has concerns, we're here.
So here are the two options I'm going to offer. We can do it now, or you can have until the close of business tomorrow to send me in writing your concerns with the form of this judgment, Mr. Helfand.
If those are my only options, Your Honor, I will take the latter, please.
All right. By 5 p.m. tomorrow, I have the form of the judgment the plaintiffs have submitted. I do find that the evidence presented proves up the damages that the plaintiffs have testified to. I find that the testimony regarding the attorney's fees to have been comprehensive and detailed, and the court is aware of all the work that went into this case. I have only to look at my court's file and the various motions and mandamuses and everything else and appeals that have been filed in this matter. So, Mr. Helfand, I'll give you till the close of business tomorrow to send me something, and I will get a judgment entered early next week.
Very well, Your Honor. Thank you very much for your time. May I be excused?
You may be excused. Thank you.
Thank you, Judge. Thanks for allowing me to prepare by Zoom. I appreciate it.
Thank you. Thank you all.
Thank you.
You'll hear from me early next week.
Thank you.
Oh, you're welcome.
Oh,